Maybe. Okay, wait to mention
Yes.
this thing on CRP IO lordship.
Yes. When?
Before vacation lordship.
Before vacation, is there any urgency?
Yes, lordship.
How?
Because there is an injunction order against which I have came lordship, and
Hmm.
this is notice has already been
Injunction
served
granted or
and they have
refused?
filed Okalatnama lordship.
Injunction granted or refused?
Granted lordship.
Granted.
Against me lordship.
Hmm. Let it be after vacation, immediately
And
after
there is an
reopening.
urgency, that is why lordship.
Pardon?
There is an urgency lordship. Yes.
Okay.
Like a motion day, Lordship. Tomorrow, Lordship. Tomorrow already 44 cases in the,
Day after- day
in the
after.
daily list. Then you supply also to Friday, Thursday, every day all.
More than 40 cases are fixed already tomorrow.
Last day opportunity, last day.
11.
11.
You can try.
I'm hopeless.
Yes, last item.
Yes.
Not at the cost of other litigants.
As last item.
Lordship, with the consent of the other side, Lordship, I beg to mention item 25, Lordship. This is hearing matter, Lordship. I am for the appellant. I have taken consent from the respondent, Lordship. Let the matter will come up after vacation, Lordship.
This is appropriate learned counsel for the appellant with consent from the other side, first for listing the matter after vacation.
Lord.
Okay, fair alone.
I have similar draft in item number 23 and 24.
Okay.
I have already obtained consent.
On the pair being made by Mr.
Respondents, my lord.
MS Talukdar.
Yes, my lord.
Learned
And
counsel for the respondent
respondent consent obtained, my lord. And
with consent from the other side, plus for listing the matter after vacation.
after vacation.
Okay.
My lord, interim order is there in
Interim order in
in
FAO.
favor of the petitioner, my lord. That may be continued.
In which item interim order is
both,
there?
Both the item, my lord, covers both the item.
Interim order passed already, etc. Yes.
May I please, Lordship? I beg to mention item number 4, Lordship.
Four.
4, yes. Lordship, may kindly adjourn this matter for today, Lordship.
Mr.
JDAS.
Zedas, learned counsel for the petitioner, press for listing the matter. When?
After vacation, Lord.
After vacation.
Publish.
Please, your lordship. Lordship, I beg to mention for listing of an RFA, your honor.
When?
First week of May, your lordship.
First week of May. Take a date from him.
On
May I please,
5th May.
Lordship?
5th May.
Lordship, item number 6, CRPIO, I beg to mention for adjournment, Lordship.
Mr. S. Paco, learned counsel for the petitioner, press for listing the matter after vacation.
After 4 weeks.
After 4 weeks. Okay. After 4 weeks. Fair alone.
Publish.
May I please, your lordship? Your lordship, I beg to mention for listing when I am pertaining to RSA matter, lordship. I have first stay vacating, lordship. So, lordship, I beg to mention for listing on tomorrow, lordship. There is an urgency.
Tomorrow not possible.
The day
After
after
Bihu,
tomorrow,
Lordship. After Bihu. On 21st.
No, lordship, there is an urgency, lordship.
How?
Lordship, after obtaining the stay order, the other side is trying to, opposite party is trying to disturb the peaceful position, peaceful and creating nuisance, lordship. So, lordship, we prefer some listing on tomorrow or the day after.
Tomorrow not possible.
The day after tomorrow, lordship.
We will try as last item.
On 10th. On 10th.
10th.
On 10th as last item.
Yes.
My lord, one item number 15, my lord. There, I had filed an application for enhancement of the compensation. The other side has filed the objection.
Yes.
Filed an application. Therefore, study copy of subplans. So, my lord, let me go through and get the instruction from my client research in Changlang in Arunachal Pradesh.
Yes.
Let him after 15 days, my lord, on any date fixed by your lord.
Which matter?
Item 15.
50.
Yes, I could have meet
15.
the other side lawyer, she has not come yet. 15.
Okay. Mr.
15.
R.P. Sharma, learned senior counsel. With concern from the other side, press for listing the matter. When?
My lord, can it be on 6th of May?
6th of May.
Yes.
May.
So as to enable him to go through the objection.
Objection as well as for instruction from the client.
To go through the objection filed by the respondent series. And
To get the instruction from the client. For
sorry,
to get an instruction from the client.
okay. Fair allowed.
Obligation.
May I please, your lordship? My lord, I filed a CRPIO in a pending MSC case number before tribunal Nalbari Mile. My lord, let it be come after my lord vacation, my lord, on 21st, my lord.
Second that.
May I
Yes.
please, your lordship, in regards to the item number 12, lordship,
12.
12, lordship.
Yes.
We have already filed yesterday affidavit in reply. It may be
Mm.
called for you.
Call it.
Okay. May I please, your lordship? I beg to mention in civil revision petition listing for orders 125.
25th.
25th. Okay.
Top of the list item 1, part and matter.
May it please your lordship. My lord, this matter regarding my lord, the commercial quantity, my lord. My lord, what I have understood from the judgments, my lord, which I have placed, my lord, that my lord, when any narcotic drugs is seized, my lord, then the IO should make an endeavor under section 52A before the magistrate to make representative samples, my lord. So when these samples are prepared, my lord, one sample will go to the FSL, one sample will be certified by the magistrate, and that will form part of the record. And that will be treated as primary evidence. Now, if this 52A is not complied with, then also that case will not be fatal for the prosecution. However, the prosecution will have to produce the original contraband. That is what I understood from the judgments, my lord. And that is what is the current legal position, my lord, as per Bharat Ambale's judgment. So, if your lordship may again have a look at Bharat Ambale's judgment, my lord,
Mm.
at para number 37.
Mm.
Page number 55. May I read, my lord?
No, on the other day you have read it.
Yes, yes. My lord, I'll just want to highlight the last line, my lord.
Mm.
That is what the gist of the entire case is, that, my lord.
Mm.
This, however, does not mean that where section 52A has not been complied, the prosecution would be helpless and cannot prove the factum of possession by adducing other primary evidence in this regard, such as by either producing the bulk quantity itself or examining the witnesses to the recovery. Now, my lord, in this case, my lord, the independent witnesses, they did not support the case of the prosecution. Where while one witness turned hostile, the other witness did not support the seizure. So it was very incumbent upon the court to examine the case of the prosecution, more particularly the police witnesses, more carefully when the seizure, the seized items were not produced. So in such case, my lord, where the law has been laid down by the Honorable Supreme Court, that if the witnesses turn hostile or if there is a discrepancy in the physical evidence, then it is incumbent upon the prosecution to either prove the produce the sample by way of material exhibit or
No, is it your case that the IO has not complied with the provision
No.
of section
no,
52A?
no, not my case.
Ah.
My lord, what has been, my lord, said by the Honorable
Then
Supreme Court in
is it
50
your case that even the complainant and the investigating officer has also not supported the prosecution case?
No, that is not my case. That is what is
Then-
laid down in Rizwan, and I'm not.
Maybe
Bring it
some
to
of the independent witnesses have not supported the prosecution case, but can we ignore the evidence of the IO as well as the complainant police officer?
Yes, what I want to submit is that if, say, for example, during seizure, the independent witnesses do not support.
No. That is not the proposition of law. Have you heard about the decision of Supreme Court, Constitutional Bench of Supreme Court in Baldev Singh?
Yes,
You go through Baldev Singh's decision and tell this court. Is it available with you?
Right now, I do not have that, my lord. But probably, my lord, that judgment was also relied here.
No, maybe on
Yes.
different contexts it can be relied upon.
Yes, yes.
But the proposition of law laid down in that case is that uh, in NDPS cases, even the evidence of police officers also cannot be ignored.
Yes, yes. I also agree. And that is what is laid down by the Honorable Supreme Court in Rizwan
In region.
and Jarnail Singh. Lots of judgments are there. Jarnail Singh versus State of MP, then Sunil versus NCT. There are several judgments. I'm not going into that. So my submission is that if you have not complied with 52A, that means you have not produced and you have not, then you would have you must produce the original contraband. And if you have complied with 52A, then you ought to have produced the certified samples which were drawn in the presence of the magistrate. Neither of them has been done in this case.
No. Sample was drawn up before the
Drawn
magistrate.
up, but not exhibited. Not exhibited.
Yes, I have gone through the record.
My lord, I have already gone.
So
That part is, my lord, some lapses are there, but otherwise, my lord, the prosecution case is, my lord, I think good. My lord.
Hmm.
My lord, inventory also, my lord, it is certified by magistrate, my lord. That is also exhibited, my lord.
inventory
Inventory, my lord, that is certified by the magistrate, my lord, honorable magistrate,
certified by magistrate.
my lord. That is also exhibited, my lord. It is, my lord, in exhibit list, my lord, it is 38.
Page number,
Page number, my lord, 43, my lord.
appeal memo.
The, my lord, my lord, no, my lord, in IA, my lord. The list of exhibits, my lord. Also, I already,
Paragraph number.
my lord,
Page number?
I am referring from, my lord, the list of exhibits, my lord. 43, my lord, page.
Decision. Decision of the trial court.
My lord, my lord.
Yes.
Page 43, my lord, the serial number 38, my lord.
Inventory.
My lord. And one list of samples is also there, my lord, but samples not. It is-
That's a putting. So on the other day, you have taken 3 points. So one is two Caesar witnesses have not whispered any word regarding the Caesar.
Yes.
And number 2 is this decision in Bharat Kampala,
Yes.
wherein the physical samples have not been produced before this court.
Yes.
And the seized articles were also not been produced and exhibited before this court.
Yes.
So any other point?
Any other point, my lord, may kindly see section 55 that the chain of custody. Section 55 says that at the time when the seized contraband is handed over to the OC by the informant.
That perhaps it is
Those-
Malkhana register is exhibited.
Yes, but the seals which were affixed by the OC, those seals were not exhibited.
whether there is any such requirement.
In 55 specifically says that, my lord. Section 55. Last line, my lord. To affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with a seal of the officer in charge of the police station. This has also been reiterated by Honorable Supreme Court in Mohanlal's judgment, my lord. That seals are vital to the prosecution's case to prove the chain of custody.
Where is the Mohanlal decision?
Mohanlal decision, my lord, I have not placed, but Lordship, give me some time, I will place the judgment also. But that is the law, my lord. The statute says the seals are to be affixed, and those seals are to be exhibited along with the Malkhana register. Malkhana register was exhibited, but the seals were not exhibited. And my third list,
Maybe, but is it fatal to the prosecution case? What is the consequence of non-production of the sale?
then the chain of custody will not be proved established.
But the Malkhana register has been.
Yes,
published and
Malkhana
exhibited.
register was there. But it will not be clear whether if there was any tampering done with the seized contraband.
No, is it your case that there was tampering of the seized article?
No, such questions were not put at the time of cross-examination, but
Then
but the prosecution ought to have.
no,
Yes.
to raise such a question before this court, you must have some basis. If you fail to put such question before the trial court, how can you raise the issue before this court now?
That was not put to the witnesses, my lord. I just checked, my lord. That question was not put.
Any other point?
No, that my other point will be the medical condition of the appellant number one.
Hmm.
His my lord, health condition is not very good at this stage, my lord. And regarding that, my lord, two reports were also called from the superintendent, my lord.
No, upon the merit of the case.
No further points regarding merit, my lord.
Yes, Mr. Sharma.
That, my lord, regarding my lord's chain of custody, my lord, in the judgment, my lord, para 42, that is, my lord, looked into, my lord. That was, my lord, looked into, my lord. And, my lord, no DW was, my lord, examined in support of the, my lord, accused, my lord.
Regarding the plea of
Regarding the plea of, my lord, that, my lord, chain of custody, my lord.
no evidence adduced.
Yes, my lord, in support of the accused person.
Then
That is, my lord.
any other point?
My lord, I have already submitted that, my lord, Malkhana register and, my lord, inventory. My lord, this list of samples are, my lord, exhibited before the honorable trial court, my lord. And that is sufficiently proved, my lord, the case of prosecution, my lord.
And regarding the decision in Bharat Ambale,
That, my lord, Ambale judgment, my lord, para 12, 32, then, my lord, 30, and 35.
pardon?
Ambale judgment, my lord, para 12, 32, 30, and 34. That may be, my lord. It is, my lord.
32 and
33 and 34, my lord.
what is stated in those paragraphs?
That, my lord, that 52A, that non-compliance of 52A is not fatal, my lord, to the prosecution.
Hmm.
Regarding this. Already, my lord, that is, it is also in my mobile.
No,
Also, my
52A is complied with here in this case.
my lord.
The what is not complied with the physical sample
Yes,
is
my
not
lord.
been
Yes,
produced
my lord.
before.
That part is, my lord, dealt with, my lord.
So whether this decision will be applicable in the present case or not, what is your submission?
My lord, that will not come up. That will not, my lord, because, my lord, my lord, if, my lord, we go, my lord, from PW 1 to PW 10, my lord, and except one, my lord, except one witness, my lord, other, my lord, has supported the prosecution case, my lord. Then that is, my lord, corroboration is there, my lord.
Any other point, Mr. Sharma?
No, my lord.
No.
No, my lord.
So you are admitting that the samples are not produced before the court and physical samples were also.
That is, my lord, the record, my lord.
So according to you, this is not fatal to the prosecution case.
My lord.
Heard Mr. S. Das, learned counsel for the appellant, and also heard Mr. B. Sharma, learned counsel for the expected comment. Argument concluded. Judgment reserved. In which paragraph of the Mohanlal decision, the points referred by you is taken care of?
Mohanlal judgment, my lord, deals with storage of the seized narcotics, my lord, at
Where?
para number 15,
1-5.
15.
So where it is stated that compliance or non-compliance of the aforementioned provision is
There are actually, my lord, two judgments of Mohanlal, my lord. There are two Mohanlal judgments, my lord.
Uh.
So, my lord, I'll have to
you
go
are
through.
not sure.
Yes,
who
whether
is
this
a-
is that judgment. Whether this is that judgment, my lord, I'll have to go through.
No, that's why you was supposed to
Yes, but
assist the court.
yes. If your lordship grants me some time, my lord, I can, my lord, come up with the judgment, my lord.
When?
Tomorrow, my lord. I'll submit it before the court master.
Day after tomorrow.
My lord.
No, not only you have to supply, but also you have to explain before the court how that judgment will help.
My lord.
And the consequence of this
My lord.
compliance or
custody.
non-compliance. Thirteen part, list the matter day after tomorrow. As top of the list item.
My lord. Highly obliged.
I can do top of the list matter.
I am appearing on behalf of the respondents, my lord.
All the respondents.
All the respondents.
How many respondents are there?
4 respondents are there, my lord.
4 respondents.
4 no.
But for the appellant,
Yes, my lord.
is A. Sodhuri. Who is A. Sodhuri?
Some G. Khandelwala. G. Khandelwala.
No, in the
I-
cause list name of
A. Chaudhary is there.
A. Sodhuri.
Yes, now he is appearing. G. Khandelwala.
G.
G. Khandelwala.
Khandelwala.
My lord, the last occasion also there for the long times there in several occasions they have taken adjournment, my lord. The last occasion by the order till 6/3/2025, the last opportunity was granted to them in the interest of justice.
Madam, on last occasion, one Arpal entered
Yes,
area.
he's junior.
Junior.
He's junior.
So, do you have a contact number?
Yes, I have contact number.
You furnish it to courtmaster. Courtmaster will contact him, and we will take it up later on. Today.
Today.
After some time, in the meantime, he will contact the council.
Obliged.
Promotional item 3. Lordship. Lordship, this is an application under section 24 of CPC, Lordship. The divorce case is pending in the court of Principal Judge Family Court number 2, Kamrup Metro. And the petitioner is living with her parents, Lordship, in Shivsagar.
No, the respondent is the permanent resident of Guwahati.
Guwahati, Lordship.
And he is also a service holder,
Yes, it's not service holder lordship, tax consultant,
maybe.
private job. Tax consultant, he is a tax consultant lordship. And she is from Sipsagar.
Mm.
And now she is living with her parents in Sipsagar lordship.
Mm.
And she does not have any income source or any other lordship source.
No, whether the present petition, no, present respondent would be able to contest the case at Sipsagar.
Yes, lordship.
How? He is only a private job holder.
No, lordship. Respondent lordship, petitioner also does not have any income source lordship. He has an income source that he is a tax consultant, but the petitioner has no other income source and she is totally dependent on her parents and is living in Sipsagar with her parents. And also no maintenance has been given by this respondent lordship.
Heard Miss RDB,
RDB,
learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring of FC within the civil case number 1404 of 2024. Pending before the Court of Learned Principal Judge Family Court number 2 Kamrup and Guwahati to the Court of Learned District Judge Sipsagar at Sipsagar. The learned counsel for the petitioner submits that the petitioner hails from Sipsagar district and presently she is living with her parents at her parental abode in Sipsagar district, from where it is difficult, it would be difficult for her to contest the petition filed by the respondent herein before the principal judge family court number 2 at Guwahati. And as such, the said case is required to be transferred from the Court of Learned Principal Judge Family Court number 2 Kamrup Guwahati to the Court of Learned District Judge at Sipsagar. Further, the submission of Ms. Devi, learned counsel for the petitioner, needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with KD and also by usual process within a week from today. Is the matter after 4 weeks. Interim period of the petitioner will be considered on next day. Let the other side appear. We'll consider.
The
You
next
take
date is
step.
on 20, next date is on 3/5/25 lordship.
Okay,
Already
so that day you take a step.
Lordship.
And then 5.
Lordship.
My pleasure, okay. Petitioners were the claimant in a MSCT proceeding, my lord, and they have sought for time to file their evidence for the 5th time. It was rejected and closed the evidence, my lord, against
How
them.
many adjournments you have taken there?
Prior to that order, 4 adjournments.
4.
Ah,
And how many adjournments you are entitled to as per provision of law?
actually, my lord, as per CPC, there is 3,
3.
but that is not mandatory, my lord.
Hmm.
And secondly, my lord, in this case, actually, they tried to settle the matter in the Lok Adalat, but ultimately it was not fortified. And my lord, on that day, my lord, on 10th of March, it was sought for on the ground of the absence of the counsel, my lord. And secondly, my lord, this MSCT,
Whether that is a just ground,
my lord,
whether absence of counsel is a just ground for adjournment.
my lord, maybe, but for the counsel, the party should not be suffered, my lord. That is
That always that proposition is always not
because he was
acceptable.
not there, and my lord, since this is a beneficial legislation, my lord.
maybe.
That impugn order is at page 14. my lord.
Since the legislation is beneficial, the court cannot grant you time for an indefinite period.
My lord, that is there. One last chance be given, my lord.
But Mr. Sahu, learned counsel for the petitioner. His petition under Article 227 of the Constitution of India is referred by the petitioner, challenging the order dated 10/3/2025 passed by the learned member, Motor Accident Claim Tribunal, Lakhimpur at North Lakhimpur in MSC case MSC within bracket date case number 13 of 2024. It is to be noted here that by the impugn order dated 10/3/2025, the learned member, Motor Accident Claim Tribunal, North Lakhimpur, has refused to grant adjournment to the petitioner and thereafter reject the petition filed by the petitioner. Reject the petition number 139 of 2025 filed by the petitioner and close the claimant's evidence and fix the matter for evidence in affidavit of deed of use. Mr. Sahu, learned counsel for the petitioner, submits that the petitioner has instituted the claim petition before the learned tribunal, motor accident claim tribunal, not talking for. And the said case was fixed on 10/3/2025 for evidence of the claimant side. How many witnesses you have examined so far?
No, my lord, first witness.
Mr. Sahu, learned counsel for the petitioner, submits that the petitioner has already availed 4 adjournments. And on 10/3/2025, he filed a petition. The petitioner filed a petition for granting her time to file the evidence in affidavit. But on account of absence of her counsel, she could not file the evidence in affidavit. And she may be granted one last opportunity to adduce her evidence, otherwise serious prejudice will be caused to her. Therefore, Mr. Sahu has contented to allow this petition. But I having heard the submission of learned counsel to the petitioner, I have gone through the petition and the pleasant record and so carried the order dated 10/3/2025. It appears that the petitioner has already availed pre-adjournment on 30/9/2024, 11/11/2024, 6/12/2024 for adjournment, and on 27/1/2025, and on 10/3/2025, again she has filed on petition on the ground that her counsel, Mr. Nitul Roy, left for Calcutta for some urgent work. Since the petitioner had failed to examine a single witness in support of her claim, and since on the date fixed, that is 10/3/2025, she could not file the evidence in affidavit on account of absence of her standing the absence of our contacting counsel. This court is of the view that one last opportunity has to be afforded to the petitioner to adduce her evidence. Then accordingly, the impugned order dated 10/3/2025 is then set aside and was. The learned tribunal is directed to afford one opportunity, last opportunity to the petitioner to adduce her evidence. Adduce her evidence. However, the petitioner has to pay a sum of rupees 2,000 being the cost before the learned tribunal before next date. In terms of this CRPIO stands dispose of at this motion itself,
Cost of rupees, my lord.
2,000 before the
1,000, my lord. 1,000, my lord.
Item 7.
Publish.
This revision fee application has been filed, Your Lordship, challenging the order dated 39/2024, Annexure J, page 55. Passed by the learned Court of Civil Judge, Senior Division, Soraido, whereby this impugned judgment has two parts, Your Honor. The one application, there is a two application has been filed, and my application, the defendant number one, I am the defendant number one in the main title suit. My application has been is pending, but observing the wrong footing, Your Honor, page 59. Page 59, there's a second part of my application. Discussion about my applications. Order file under Order 9, Rule 7, Your Honor.
Page number
59. Second part, Your Honor. Page 59, second part. Learned advocate for the defendant number one. In this case, I am a petitioner. File a petition number 290/24 under Order Rule 9, Order 9, Rule 7 of CPC for vacation of ex parte order against the defendant number one, dated 35/2024. There's an ex parte order has been passed against the petitioner, defendant number one, Your Honor. That the contents of the petition, that is important, that the contents of the petition are definitely refer to the Order 9, Rule 37. But the court and let it remain clear that Rule 7 of Rule and Rule 13 of the CPC are interrelated in Order 9. But the Order 9, Rule 13 has been is a different proposition. It is a different set of has been set out for ex parte decree. But wherein I have filed the application for Order 9, Rule 7, but the court below has ought to have taken my application under the provision of Order 9, Rule 13 instead of Order 9, Rule 7. For that wrong proposition has been drawn by the learned court below. I have filed this application for taking my application under the provision of Order 9, Rule 7, not under the Order 9, Rule 13, Your Honor. That is a remedial pair. The court below has, I have filed the Order 9, Rule 7 for vacating the ex parte order, but instead of the court below has taken my application as a Order 9, Rule 13. The way there's a settled law, provision of law is that a state to where a state to has been made a particular thing to be done in a particular manner, that ought to be have been done in that way. But the court below.
Where is your petition?
My application has been Annexure I, page 48. The cause of action that the application has been filed under petitioner defendant number one, under Order 9, Rule 7, read with Section 151 CPC for setting aside ex parte order dated, not decree. The suit has been still pending. The court below has taken a wrong proposition that the petition should be treated as Order 9, Rule 13. Order 9, Rule 13 is setting aside ex parte decree, Your Honor. Order 9, Rule 13 of CPC says setting aside an ex parte decree. But Order 9 Rule 7 said. So I am very much agree of this that my petition is going to be disposed of or rejected under the provision of Order 9 Rule 13 instead of Order 9 Rule 7. Since the court below has taken a view that it should be taken as Order 9 Rule 13. The ex parte order has been passed against me on 13/5/2024 of non-appearance of that particular day. And immediately after knowing of the ex parte order, I have engaged one advocate and filed this application. But the court below has taken a different notion that the application should have been taken into an Order 9 Rule 13, which is not under the purview of this.
No, that petition is yet to be disposed of. The learned trial court has directed to register a misdeed case upon the petition filed by you.
Noted.
So you argued the matter before the learned trial court at the time of the hearing
Logic.
that your petition is under Order 7, Order 9 Rule 7, not under Order 9 Rule 13.
But the court below has stated that
Is it not a primacy or?
But the thing is that the contents of the petition definitely refer to the Order 9 Rule 13. Let it remain clear that Order 9 Rule 7.
Maybe, but at the time of hearing, you pointed out to the learned trial court.
Logic. No, we have already raised this issue. We have already raised this issue.
No order was passed by the learned trial court now. Only directed to register a misdeed case.
Misdeed case, but the thing is that
But at the time of hearing, you pointed out.
At the initial stage, during the argument of this petition, I have raised these issues. It should be taken into Order 9 Rule 7. But the court below has a view.
We are closing this petition, granting liberty to you to raise the issue before the learned trial court at the time of hearing of the petition.
Logic.
No? Mr. H. Borwa, learned counsel for the petition. This petition under Article 227 of the Constitution of India is preferred by the petitioner challenging the correctness of the order dated 38/7/2024 passed by the learned Court of Civil Judge Senior Division Sarajevo entitled suit number 1 of 2024. Mr. Borwa, learned counsel for the petitioner, submits that the petitioner is the defendant number
1
entitled suit number
1/2024.
Number 1 of 2024. And the petitioner could not appear before the learned trial court on. Who is that?
There is an ex parte order dated 13/5/2024. 13/5/2024.
Where is that order?
Lordship, sir. Ex parte setting as an ex parte order dated. Yes, Lordship. Just one. Annexure H, page 46, dated 13/5/2024.
On 13/5/2024, for which the learned trial court has decided to proceed the case ex parte against the present petitioner. Thereafter, the petitioner on 30/9/2024 filed an application under Order 9 Rule 7 reviewed Section 151 of the Code of Civil Procedure for setting aside the ex parte order dated 13/5/2024. But the learned trial court, by its impugned order dated so and so, observed that no, learned trial court has directed to register a misjay case upon the said petition number 290 of 2024 under order 7, order 9 rule 7, but made one observation that the petition definitely refers towards order 9 rule 13 of CPC. Mr. Borua, learned counsel for the petitioner, submits that the case of the petitioner is covered under rule 9, order 9 rule 7, not under rule 9, no, order 9 rule 13 of the CPC as observed by the learned trial court. But it appears that no effective order has been passed by the learned trial court till that, though such an observation is made in the impugned order dated so and so. It appears that the learned trial court has directed to register a misjay case upon the petition number 290/2024. Under such circumstances, this court is inclined to dispose of this petition by granting liberty to the petitioner to raise the issue before the learned trial court at the hearing of the petition number 290 of 2024 that his case is covered under rule 9, order 9 rule 7, not under order 9 rule 13 of the CPC. In terms of about this PIO set forth that is motion is set. Lord,
29.
May I please your lordship? My lord, this is this revision petition against the order passed by the executing court. The facts of the case is this, my lord. The respondent filed a suit against the petitioner for declaration of right title interest and recovery of possession. The suit was decreed and we prefer an appeal. In the appeal, we have not paid for stay of the execution of the decree. Taking advantage of that, the decree holder plaintiff execute the decree, tried to execute the decree and partially successful by demolishing because the land of the petitioner and the land of the respondent are the adjacent. Taking advantage of this, the decree holder demolished some portion of my house and disconnect the electricity. Thereafter, I filed a petition before the appellate court and the appellate court stayed the decree. Thereafter, my lord, when the execution case is proceeded, we filed a petition for survey commission. One survey commission was appointed and he gave a report which was not accepted by the court. Thereafter, second survey commission report was submitted, and that also is not clear. So far, the disputed suit land and my land. Then I filed a petition under section 47. That petition was rejected. Against that, then again I filed a petition containing some additional ground that without appointment of the survey commissioner to locate the exact boundary of the plaintiff and the defendant, decree cannot be executed. The learned executing court rejected my application on the ground that the earlier 47 petition was rejected. And on that point, the executing court cannot dismiss my petition because there are some subsequent development here. Therefore, against that order, I have filed this petition.
What is that order?
My lord, at this stage, my lord, order is at page 185. Operative part is at page 190. Bottom.
Page number?
190. Page 190. Upon upon careful consideration of the facts and circumstances as discussed above, I am opinion that the principle of res judicata is applicable in this case. The issue raised in the present Mizze case number so and so have already adjudicated by the court in Mizze case number so and so. The Honorable Court as well. The judgment and the judgment letter after attempting to reagitate the same issues and attain the finality. As such, the present application is barred under section 11 of the Code of Civil Procedure. Further, the decree holder who is now in the advanced age and suffering from various ailments in enduring an undue delay in realizing the right to decree. The prolonged litigation has caused the significant mental and physical distress to him and continuing attempt to the judgment letter to prolong the matter as serve only to execrable and hardship to the decree holder. In this, I deem it too prudent to put the judgment passed by so and so. Order 39 Rule 101 categorically the adjudication. Order 21 Rule does not necessarily involve the detailed inquiry in collection of evidence. If by filing such application, the another front can also be opened. No decree reached the logical conclusion, and the decree of the civil court will be in a mere decree. In view of the above observation, it may be concluded that the very basis of the claim of the objector is earlier negative the trial court as well as the High Court. The order dated 11/5/15 passed by the executing court has attained the finality. Having the upheld by the Honorable High Court in order dated so and so, no further proceeding applicable should be entertained in the same legal principle. This judgment letter second application is nothing but an attempt to circumvent the final order passed by this court. The earlier petition and the present application is not same.
So on what ground this order is illegal or arbitrary?
Well, the earlier application is on the different point, and the second application is on the different point.
Whether both the applications are part of the record?
Yes, yes.
Page number?
Page number 82, Your Lordship kindly turn. Page 82. Page 82, prayer portion, Your Lordship kindly see. It is
Page 82.
82. Prayer portion, Your Lordship kindly see. It is therefore prayed that Your Honor be pleased to inquire the matters by spot verification and say be pleased to find out the articles of money money locked by the appropriate and their hired and during the execution of the derived and after proper inquiry and after hearing the parties necessary order. The earlier petition is this. In the execution case, they demolished a part of my house and took some belongings of me, including the disconnection of electricity. On that petition, we filed this revision petition, 47 petition. The prayer of this 47 petition and the present 47 petition is quite distinct and different. Therefore, it cannot be said to be barred under the provision of res judicata. Parties may be same, but the subject matter of both the petitions are same.
And the other petition?
I 165. One 165 prior procedural responsibility.
That page number?
165. In the premises, it is therefore prayed that the Honorable Court may be graciously pleased to admit the instant petition, and further may be pleased to determine the question of identification of the decretal land put to execution in title execution so and so by identifying the area, location, boundary of the Schedule A decretal land, and B plus this pair of these two petitions are quite distinct and different. And the learned executing court held that it is barred by res judicata. It cannot be said to be barred by res judicata. Subject matter of two petitions are
Different.
different. My lord, at this stage, the notice may be issued, and I am not praying for stay at this stage. Let them appear.
It is a typical for court to stay execution, grant stay in execution proceedings
No,
because
I am not praying for stay.
recently Supreme Court has directed that within 6 months a decree has to be executed.
The Supreme Court has ordered the decree has to be executed, but within 6 months it is not possible. Your Lordship kindly remember, once the Supreme Court says the stay passed by the court is effective up to only 6 months. But that order also revoked and modified by the Supreme Court itself. Something is not possible and impossible. A execution case cannot be disposed of within 6 months. Your Lordship knows it is very well.
No, that's all right, but it is the direction of the apex court of the country.
No, it is a direction of the apex court, no doubt, madam. I am not disputing and I have full respect to the Honorable Supreme Court. But in practical field, it is not possible. And your Lordship also knows that.
Even it goes to the extent that departmental proceeding or other proceeding would be initiated against the presiding judge who failed to execute the decree.
That
So this
a
kind of
presiding
directions are
officer
also
cannot,
there.
my lord, a presiding officer cannot fear about the departmental proceeding. A duty of the presiding officer is to give the justice to the parties.
But what to do? That is the direction of
My
the.
prayer is this: a notice be issued. Let them come and say what is what. And I am not praying for stay.
Third Mr. S. S. Sharma, learned senior counsel assistant by Mr. G. Vardas, learned petitioner. In this petition under Article 227 of the Constitution of India, read Section 115 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 28/10/2024 passed by the learned civil judge. Junior Division number 3, Kamrup and Guwahati, Mistake case number 307 of 2023, arising out of title execution case number 41 of 6 Certificate 4, and title execution case number 21 of 2015. New. It is to be noted here that by the new order dated 28/11/2024, the learned executing court has dismissed the petition number
By the order dated, order dated 9. 2011-24. Major case number 307 of 23. Order dated 2011-24.
Dismiss the miss case number 307 of 2023 filed by the present petitioner under section 47 read with order 21 rule 101 and section 151 of the Code of Civil Procedure, wherein the petitioner has right for determining the question of identity of the land put to execution. Peruse the petition and the documents placed on record, and also peruse the impugn order dated so and so. That notice be issued to the respondents returnable in 4 weeks, that be taken by registered post with AD and also by usual process. There is only one respondent.
One is
Respondent returnable in 4 weeks, that be taken by registered post with AD and also by usual process with a week from today. Release the matter after 4 weeks.
Pending item 2.
I'm for the petitioner. I'm for the petition appellant in this case. For the last 6 months, we've been asking for the document from the petitioner, but they couldn't trace out the document. And few days back, we have received one mail from the petitioner stating that we don't have to appear in this case. So
What is the instruction?
that we are not supposed to appear today.
You are not supposed to.
Yes.
So they have taken away the file from you.
No, not yet. They have taken the file, but couldn't provide us the documents.
Moreover, madam, they have not issued any ukalknama to
Yes,
them
yes.
also.
You have not filed any ukalknama.
Ukalknama. Then, if they are not interested to prosecute the matter, my lord, the last long period, they're taking adjournment, my lord. It will be closed, my lord.
Your good name, please?
Paul.
Paul. Heard Mr. R. Paul, learned counsel for the appellant, and also heard misuse of property, misuse of property, learned standing counsel, NFL. Mr. Paul submits that the party has not provided him with the documents, with the relevant documents, and also they have not filed the Ukalotnama till today and instructed him not to appear in this court. The learned counsel for the respondent, Ms. Chakraborty, submits that this appeal may be closed. Yes, the parties have failed to prosecute the same, and it is pending since the year 2014. By taking note of the submission of learned counsel for both the parties, it is provided that the registry shall raise the matter immediately after reopening of the vacation on 30th April. And in the event of failing to appear before the court on next date, appropriate order by the appellant, appropriate order shall follow. In the meantime, registry shall issue notice to the appellant. Your name should be deleted from the cause list.
No.
Your name is not there, of course.
Yes, not there.
Okay, on that day, if the parties fail to appear, then we will take a call.
Otherwise, it will be closed, man. Otherwise, it will be closed, my lord. The long
We
period
will
is fine.
take a call.
Yes, man. Obliged.
Item for admission Item number 8, part matter.
May I please, Lordship? Lordship, this matter is relating to non-payment of salary, Lordship, as well as the pensionary benefit, Lordship. The petitioner was appointed in the year 1995, Lordship, as a state pensionary officer. Thereafter, he was sent for Lordship training. Basic training was passed, Lordship. Then in this case, is related to Shivsagar district. In Shivsagar district, Lordship, from March 2012, Lordship, there is a allegation that this present petitioner, including many incumbents, they are irregularly appointed, Lordship. That is why their salary was stopped from March 2012, Lordship. Then, Lordship, we made a prayer for salary. Inquiry was conducted. Kindly see, Lordship, page 48. For reminder,
Mr.
Lordship.
Talukdar, you have filed affidavit.
My Lord. They have filed affidavit, Lordship. As per their affidavit, Lordship, I am entitled to get the everything, Lordship. Now
Pardon?
they have filed this affidavit in a pro forma format. They have not gone through the record. And in their affidavits and record, Lordship, I am entitled to get the everything as a regular teacher and benefit, Lordship. In the meantime, I have retired in 30 January 2021, Lordship. But the affidavit has been filed is a common affidavit, Lordship. Nothing, everything is in my favor, Lordship. And in their affidavit record is there, Lordship. Lordship would like to see the affidavit filed by them.
So you have been appointed
Step and date, sir.
on, who is that?
16/9/1995. 16th September.
What is the appointment order?
Lordship, appointment was page 26, Lordship.
Page number?
Page 26. Type copy, Lordship, honest. Page 27 is the shortest, and page 26 is the type copy, Lordship. My name is Torun Gogoi, Lordship. Thereafter, Lordship, by order dated 30/01/2002, I was allowed to do regular scale of pay with effect from 12/6/2001, Lordship. Page 28.
When you have been appointed as a regular teacher?
Lordship, I was allowed, initial appointment is 16 and thereafter, Lordship, that order is not there. That order is not there. In the end, I was sent for training, Lordship. I passed the training, and with effect from 12/6/2001, I was allowed to regular scale, draw regular scale.
On who is that?
The order dated 3/1/2002. 3/1 and effect from 12/6/2001. Page 28.
Allowed to draw regular scale.
Yes, Lordship, with effect from 12/6/2001. Page 28, Lordship.
12/6.
12/6/2001.
Page number?
Page number 28, Lordship. The type copy.
Yes.
Lordship, thereafter.
Prior to that, you have undergone that basic training?
Yes, Lordship. Yes. Thereafter, Lordship, my salary was stopped from March 2012. Then I filed the application.
When you have undergone the basic training course?
Lordship, the order is space 28, Lordship. The order is 3/1/2002. Allowed to draw the regular scale. 3/1/2002.
3/1?
2002.
2002. No, you have been granted regular scale of pay with effect from
12/6/2001.
2001.
Yes, with
And
effect
this
from
13/1/2002. This
is
order?
order. The effect is given for the previous period, bygone period, Lordship. There is a common order effect from this. I have served the period, Lordship. sorry, Lordship. 31, 12/6. I was sent for training, Lordship, 12/6/2001. Sorry, Lordship. Training, I was sent, 12/6/2001, Lordship. Sorry, Lordship. Yes, Lordship. I'm sorry. 12/6/2001. Yes, Lordship. Yes.
And the order was passed on regular pay scale?
31/2002, Lordship. Sorry, Lordship.
Yes.
Thereafter, Lordship, from March 2012, my salary was stopped, including many others, alleging that we are illegally appointed access appointment, Lordship. Then we have filed a
March 2012.
yes.
Salary stop.
Then, Lordship, we filed an application, and pursuant to our application, an inquiry was conducted, Lordship, by the authority, that is space 48, Lordship.
You have filed a rate petition.
No, Lordship, a petition before the authority, Lordship, for stopping. Then, Lordship, pursuant to our application, an inquiry was conducted by the Deputy Secretary of the government level, that page 48.
Representation filed on?
Lordship, that presentation, it is mentioned there, Lordship.
Is it part of the record?
No, Lordship, it is mentioned in our petition, Lordship, but that is not there. Commonly filed some people, Lordship.
So that's all. What is the date?
9 May 2012. 8:48.
Yes, Lordship. 9 May 2012.
May 2012.
12.
Page number?
Page number 48. This is the inquiry report.
Yes.
Now, Lordship, here my name, Lordship, kindly may I read, Lordship, page 48 for a moment.
Page number 48.
48, Lordship. This inquiry was conducted by the Deputy Secretary, and report was submitted to the Directory of Education. Lordship, subject regarding release of salary LP school teachers under Shivsagar district. Lordship, with reference to the above, I am directed to say that from your report, it reveals the name of 8 petitioners. Lordship, here my name is a serial number 1, Lordship, Tarun Gogoi, are within the 610 LP post allotted for Shivsagar district against 8153 post created by gov letter number so and so. And the incumbents are appointed by the Deputy Inspector of Schools, Nazira initially. Now, Lordship, second para. From records, it also reveals that the names of 8 petitioners along with relevant information were submitted by the then Inspector of Schools, Nazira so and so, so and so. Now, Lordship, the last line. The names of following 5 petitioners were also included within the incumbency list of 388 LP teachers under DIS Nazira. Now, Lordship, serial number 1, Tarun Gogoi. This is my name. Now, Lordship will skip and next page 49. 49. Lordship, in view of the above, you are requested to examine the matter properly based on authenticated records and submit a detailed factual report as to why the names of 8 aforesaid incumbents were included within 1528 access LPTs under Shivsagar district. Whereas as per record report, all those were originally appointed against sanction post created by gov letter number 18195, having up to date temporary retention up to so and so. The report, this is the inquiry report left, and it was directed to the director to submit the report. Lordship, pursuant to that, Lordship, nothing has been done, any intercommunication has been taken place. Then I filed a writ petition, and there is a direction, page 51, Lordship. Page 51 order. Page 51, WBC number 188/2013.
Page number?
51, Lordship. 51, operative part, Lordship. It starts from page 51, and the operative part, Lordship.
So what is this annexer 10 then?
The Lordship, annexer 10. Annexer 10 is the Lordship, is a direction by the Deputy Director to District Investigation to inquire and submit the report.
Thereafter inquiry was conducted?
No, Lordship, no, nothing. Then I filed a, then when nothing has been progressed, I filed this writ petition, Lordship.
Hmm.
That is, Lordship will find the operative part, Lordship, page 56, Lordship. An order dated 6/5/14. Page 56, Lordship.
Yes.
56, last two paragraph, Lordship. It appears that petitioner in WPC number so and so, this is another similarly situated case, Lordship, were denied their salary from March so and so, whereas salary of the petitioners in the present case were stopped, albeit without any written order with effect from March 2012, except for the period. It appears to the court that the appointments in both the cases relate to the same period under OBB in the same subdivision, and all those appointments pertain to 610 posts are marked for subdivision Nazira. In this circumstance, I saw no good reason to take a view different from the one taken in the judgment and order so and so, past in so and so. Next, accordingly, a writ of mandamus is issued to the respondent authorities to pay current salary of the petitioner within a period of 1 month from the date of receipt of this order, and to release the arrears salary of the petitioners within a period of 3 months from the date of the receipt of this order. The respondents are also given liberty to complete the inquiry that I have shown page 48, Lordship. It was made clear. Inquiry stated to have been pursuant to the letter dated 9/5/2000. That is also not done, Lordship. Court is cleared, you pay the salary, and also if you want, carry on the inquiry pursuant to the order dated 9/5/12, Lordship. This is the direction. Pursuant to the court's order, Lordship, my salary was given, Lordship, release. Page 58. There are number of teachers, and with the 8 petitioners are there, Lordship.
Salary release.
Yes,
Release.
Lordship. That is page 58, 19 May 25. Lordship will find serial number 15, Lordship. Torun Gogoi, Lordship. That is the period, Lordship, in the right hand side, 31/3/2012 to 28/2/2015. This salary was released then, Lordship. And I got the salary till date 2015, Lordship, pursuant to this court order. And the subject is, Lordship, and this is subject, creation of 20 supernumerary posts in respect of so and so, so and so. These are different case, Lordship. And my case is a 188 serial number. My name is 15. So I have got the salary 28 February 2015, Lordship. Then, Lordship, again salary was stopped, Lordship. Then I did not file the contempt petition when they stopped the salary. Then I filed another writ petition. When time has passed, that is page 59, Lordship. Page 59. And my name appear at a serial number as a petitioner 7.
Thereafter, since when your salary was stopped?
Maybe till 15, they have given the arrear salary, everything. Regular salary, monthly salary, that is was stopped, Lordship. Regular monthly salary was stopped. That arrear they have given pursuant to the court's order till February 2015.
Okay.
Then, Lordship, again my salary they did not release. I again came before this honorable court. Lordship, kindly see the page 59. There is another writ petition, WPC 3628 of 2016. Second writ petition, page 59. Page 59, Lordship, my second writ petition. And page 59 is starting, and my name at serial number 7, Torun Gogoi. And the operative part, Lordship, order dated 28/4/17. Now, operative part, Lordship, page 63, Lordship. Page 63, the second prayer, Lordship. From a consideration of the stand taken by the respondent, Education Department, the affidavit of the Commissioner and Secretary, it is apparent that a contrary decision as contemplated in the earlier order dated 6/5/14, which I have shown, Lordship, had not yet been arrived at by the respondent authorities. In such view of the matter, this court cannot take any other contrary view and is bound to follow the earlier direction of this court dated 6/5/14 in WPC number so and so. Accordingly, this petition is disposed of with a direction that, as contained in the earlier order dated 6/5/14, the respondent authorities shall continue to pay arrear and current salary to the petitioner till a contrary decision is arrived at by the respondent authority. It is stated that as per the earlier order dated 6/5/14, the petitioner were paid their salary and up to February 2015, and therefore their salary and allowances from March 2015 till date would be constituted to be arrear salary. The current salary henceforth shall be continued to be paid till a decision is arrived at, and the respondent shall also pay the salary from February 2015 till date. This is the direction, Lordship. I did not get any salary till then, Lordship. In the meantime, I have retired from 31/1/2021, Lordship, from service. 31 January 2021, Lordship. And then my retirement certificate at page 65, Lordship. Retirement certificate, page 65, issued by the BO, Lordship.
Page 65.
65, yes, Lordship. This is issued by the Block Limit Education Officer, Nazira. This is to certify that Sri Torun Gogoi, assistant teacher who retired from service on 31 January 20 from so-and-so school under Nazira Education Block as supernumerary teacher, Lordship. This post was created as supernumerary teacher. He got his salary up to February 2015, and from that time he had not got his salary up to date of his retirement, Lordship. Now, Lordship, during
Mr. Talukdar, why this order has not been carried out?
My lord,
Have you filed any appeal?
no, my lord.
No. What is your stand in the affidavit?
Our stand is that, my lord, he is a irregular appointee, my lord, excess teacher. During the OBP teacher.
No, whether you have carried out any such inquiry?
Inquiry, my lord, inquiry conducted in entire Sibsagar district, my lord. And
No,
subsequently,
you
my lord,
must come to this Annexure 9, page number 48.
and Lordship, or from their affidavit, it is in my favor, Lordship.
Pardon?
If they have filed the affidavit in this case, and it is there as per their recommendation, I am entitled to get everything, Lordship. It is there, Lordship, in record. Let me.
You have appeared?
No, Lordship. Yes, I have appeared, Lordship. Inquiry was conducted, and as per the inquiry, I am come in the category of to be regularized, Lordship, and entitled to the salary, Lordship.
No, whether that inquiry report is part of the record.
Not just the entire throughout the district, Lordship, throughout the state inquiry, cabinet decision was taken. Throughout the state inquiry was conducted, and I also submitted the application.
No, why you have not brought on record that inquiry
It is fine. It is in their affidavit, Lordship.
in their affidavit?
Yes, Lordship.
inquiry report is not there, my lord.
No, not pursuant to this inquiry. The order dated page 48, Lordship. That is a common inquiry report, Lordship, throughout the state regarding illegal and excess appointees, Lordship.
Yes.
This is not pursuant to this my page 48, Lordship. This is the throughout the state inquiry was conducted, Lordship, regarding this illegal appointment, and Shivsagar district also included there. And person similar to me, they are also their service in the regularized and they are getting the salary. May I take your Lordship, their affidavit, Lordship, for a moment. The page 79, Lordship. Yes, continue, page 79. I think Lordship will rise,
That is
Lordship.
cabinet memorandum.
Lordship will rise maybe after some time.
Okay. So, Mr. Talukdar,
My lord.
why the order passed by this court in the second writ petition has not been carried out? You have not filed any appeal also against that order?
My lord.
No review petition also filed?
Our contention is that, my lord, as he is a
No, your
excess appointee,
contention
my
is
lord. that's
different
why-
thing, but Mr. Talukdar, you first carry out the order.
My lord.
You obtain instruction, we will take it up at 2 o'clock. Why the order of this court dated
6514 as well as
28/4/2017 is not carried out.
Oh, Lordship may taken up immediately after vacation, my lord, in the meantime.
No, no, no.
Call the record, my lord, so that whether this inquiry report is clear or not. That may become a clear, my lord.
yes.
My lord, 20. No, earlier inquiry.
And Lordship, from their record, Lordship, the person similar to me, Lordship, in the meantime, who are working, Lordship, their service has been regularized, Lordship. And I am also
Not regularized, my lord, who passed the
yes.
basic training, they have accommodated as a tutor, my lord.
No, wrong submission, Lordship.
Place the facts correctly, my lord. May I point out one thing? The stipendary teachers, my lord, for all purposes are regular teachers. The only difference with regard to regular employment is that they are not paid the regular scale until and unless they pass the basic training. Once they pass the basic training, they are given the regular scale of pay. These are
yes.
for all purposes from the very initiation are genuine appointment, regular.
And I have passed the, I have passed the basic training.
It's regular.
But this the criteria is that this post will be ceased.
Until the time they pass the basic training, they are not given the regular. They are given a stipend. Yes, pass the basic training, thereafter you go.
Yes.
There are judgments to this effect. Probably you can bring those judgments on record. Numerous judgments.
Lordship, it is there from the record. Judgment is in record. That is a Lordship judgment is there with me, Lordship. But from their affidavit, I am entirely everything, Lordship. The retirement benefit also. I have brought the judgment of this.
No, that's all right. That is a different matter. But why this order dated
Yes.
28/4/2017 has not been carried out? Why you have not filed any contempt petition?
Lordship, in the meantime, inquiry was going on, Lordship, and this is a very poor person, Lordship. These are not the salary, and definitely they could not come to the court. This is the some facts, Lordship. So still fact, Lordship. And truly,
Mr. Talukdar, you informed this court at 2 p.m. Why this order 28/4/2017 has not been complied?
My lord,
This application is for enhancement of the award, my lord.
Uh.
Though I was a nun, my lord, I was working as a teacher in a missionary school, and I used to get 15,000 rupees salary. But the award has been given. There was no multiplier was applied while calculating the award. And my lord,
under whose provision the petition was filed? 166 or 163A?
This petition before your lordship is under 173. 173.
No. Before the tribunal.
166.
166.
Yes. And I used to contribute this amount to my family, my younger brothers and sisters. That has not been taken into consideration. Only notice will go, madam.
So this is a death case.
Death case. Only award is on 1 lakh, madam, something, madam. 1,34,000.
So you were the brother and sister,
Yes, yes.
and you are not dependent upon the income of the deceased.
We are dependent upon him, not fully, but we used to get help from our sister, who is a non-mother. She has renounced the war, no doubt, but we used to maintain the relation. These two brothers are a daily wage earner. Court has also questioned that how they have undertaken traveling from Bangalore to this Kokrajhar, Bongaigaon, my lord, for this claiming this petition, unless they have got sound financial capacity.
Third, Mr. S.C. Disses, learned counsel for the petition. Appellant. This appeal under Section 173 of the MD Act is directed against the judgment and award dated 10/12/2024 passed by the learned member, Motorist and Claim Tribunal,
Kajalgaon.
Sirang, Kajolgaon, in MSC case number 15 of 2023. It is to be noted here that by the due judgment and award dated so the learned tribunal has directed the respondent number 1 herein to pay compensation. No, to pay a sum of rupees
4,700.
34,075 rupees being the compensation. Being the compensation. From the date of filing the application till receipt of the award with interest at the rate of 6% per annum. Peruse the petition, peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 10/12/2024. Admit, issue notice to the respondent regarding claim for which should be taken by registered post with ATM of the usual process. Basis will call for the record for the learned tribunal is the matter of for which.
Diploma.
Right, Lordship. Lordship is very much appreciated in this regard, Lordship, regarding this. Just now I have received the affidavit, Lordship. So the last question, Lordship, Honorable directed to file a affidavit against the Lordship. The Honorable Court has already directed in regarding page 37, Annexure 6, Lordship. The BO has issued the letter, Lordship, regarding this. All documents are available, and the school was continued, Lordship, 2009 to 10, Lordship. And so here all they have denied, Lordship, in this regard. So, Lordship, kindly.
Whether they have filed their affidavit?
Just now I have received, Lordship. I have gone through, Lordship.
It is not on the record. It's affidavit filed by the SSA.
So offered.
Call for a good. When did you receive the affidavit?
Just few minutes ago.
Few minutes ago. It is not placed on record. That's good for us.
lordship into respect lordship is a personal appearance ought to be required lordship. So they have already initially admitted the facts lordship on that letter and now have denied it lordship. The response number 5 is a BO lordship. It's a personal appearance lordship. Why they have to deny it lordship right now in affidavit?
No, first, let the affidavit come. Affidavit is not before the court today.
Yes, lordship.
Mr. Sharma, you are appearing in this matter?
Hardy. Supply. Hardy 30.
You have filed affidavit today.
Lordship, in this matter, we have filed our affidavit during the course of the matter.
Till now, you have not filed.
No, Lordship. During the course of the, we have filed our affidavit.
Not alcohol.
No, my question is, you have not filed till
Copies are full.
Copies are but did not file. Not record.
let it be on 21st of April.
Yes,
Or Mr. Arsitas, learned counsel for the petitioner. And madam, your good name, please?
B. Decca,
E. Deca, learned counsel, standing counsel for the
elementary education.
Elementary Education Department. Ms. Deca submits that she has filed the affidavit in opposition. No, she will be filing the affidavit in opposition during the course of the day. Accordingly, it is provided that rest shall list the matter on the 1st of April, enclosing the affidavit filed by the respondent authorities. As ordered.
Yes.
Item 10.
In this case, the guest record of title appeal number has not yet received. Several remainder has also been issued.
From where it was called?
Borpeta, Civil Judge Borpeta. Civil Judge Borpeta.
Borpeta.
Title appeal number 66 of 17. And Municipal Court received, office note says, but record is not here.
Maybe it in the
It is
section.
on the section. That may also take.
Or Mr. J. Ahmed, learned counsel for the appellant, and Mr. G. Burdas, learned counsel for the respondent. Office note dated 23rd 12 2024 indicates that record of title appeal number 66 of 2017 has not yet been received. Accordingly, it is provided that RESI shall issue urgent reminder to the learned
Civil Judge Borpeta.
Learned First Appellate Court, that is learned Civil Judge, Senior Division, Borpeta.
Yes, ma'am.
Borpeta. For transmitting the record of title appeal number 66 of 2017 without further delay.
List after 2 weeks, my lord. After 2 weeks, list.
After 2 weeks.
Hello.
Item 11.
May I please? As per office note, Lordship, service is complete.
Service complete.
Service is complete, but LCR has not been issued.
Madam, you are appearing for?
1, 2, and 3. Respondent.
For all the
All
respondents. Or Mr.
A. Hussain.
Learned counsel for the appellant, and madam, your good name, please?
R. Dev.
R.
R. Dev.
Dev. Learned counsel for the respondent number 103. It is submitted at the bar that service has already been completed and the record has also been received and the matter is ready for hearing. Accordingly, it is provided that
Lordship, LCR has not been
LCR has not been received.
not been received. Okay. Okay. Office note dated 10/6/2020. Okay, to 4 hours. 1 year. In the meantime, he So this office notice is updated 10/6/2024. In the meantime, a record might have come. Oh, up to date office notice put up. 10/6/2024 indicates that LCR has not yet been received. But it appears that the office notice of dated that office notice of 10/6/2024. No up-to-date office note has been put up by the section. Accordingly, it is provided that the SSL shall raise the matter immediately after reopening of the petition and closing up to date by putting up an up-to-date office note in respect of the latest status of the receipt of the LCR from the learned courts below. It's according.
Item 12.
Made to do. This case was fixed today, but on parallel of record, it is found that the service report on response number 2 is not yet complete.
My lord, respondent who is, my lord, one of the sister concern of the petitioner, my lord. Now, just to delay the execution, my lord, they have made him as a opposite party, my lord. Otherwise, my lord, in the suit, both were the defendants. My lord, how the
They have included them as a party respondent.
No, my lord, in that
In
case,
the
my lord,
suit.
let the stay be vacated because, my lord, my money is, my lord, being enjoyed by them from last
I
more
have
than
no
20 years,
objection
my
if the case is taken up without service of notice. I have no objection. I am ready with the case.
My lord, how he can be made a, my lord, a respondent here, my lord. And my lord, we'll see, my lord, in the decree was passed in the year 2005. my lord. In the year 2006, my lord, both this petitioner and respondent number 2, my lord, both filed an application for, my lord, a leave of the court to defend the suit, my lord. It was a summary suit, my lord. That leave was, my lord, refused by the learned trial court, my lord. Now, my lord, how in such situation, how, my lord, that firm can be made a respondent, my lord?
Because you are the party in the suit.
Maybe he may be at best, my lord, he may be a proponent or respondent, and it is they both are same, my lord.
It is his suit. He made them a party.
And my lord, a witness was examined in the, my lord, the leave to defend, my lord. He has admitted, my lord, the both these company and the firms are having they registered in the one and same building, my lord. So just to delay, my lord, how, my lord, he can, my lord, one company is filed my lord, a petition, and their sister concern is a, my lord, a party. So, my lord, how they can say that this is not, that firm is not aware of this proceeding, my lord? They could have served a copy on them, my lord.
That is a different thing, my lord. If the
How that,
case is
how
taken
that
up,
is a necessity
I have
party.
no objection. Because later on, some objection may be
How
raised.
many respondents are there?
Two respondents were there. One is appearing.
You are appearing for?
I am the
One.
decree holder, my lord.
Decree
Respondent number 1.
And, my lord, one suit is also filed by them, my lord. They also filed a
That is
suit, my lord,
different.
challenging the decree. So, my lord, whatever, let this appeal be disposed of by this honorable court, my lord. If they are, now, my lord, their main case is that they have no liability. It was the liability of the, my lord, one of the directors of this present company, my lord. If that is so, my lord, they have filed a civil suit, my lord. If that court, the law will take its own course. If they are entitled to recover the money from me, my lord, that since this money was being paid by me to the one of their directors, certainly they will recover in the suit, my lord. They will get a decree, my lord. They have filed a suit for challenging the decree, my lord.
Oh, when did you take a step upon the respondent?
Madam,
When did you take
steps.
steps upon
A
respondent?
long
number
time
two?
back, madam, after the notice was issued. Only there is a note from the office.
There was no service.
हमारा ये तो ऐसे reply करता है।
So, Mr. Gore, you are not representing respondent number two.
No, my lord, it is there for my lord. They both are system concern, my lord. And my lord will see that they from their own record, my
If
lord.
the matter is hard, you also will come to know
when-
who is sister concerned.
No, without service of notice, how can we hear the matter?
My lord, my prayer is, my lord, that they let the stay be vacated, my lord, and let them serve the respondent.
No, we have not granted stay of the execution proceeding. Did we?
Yes, my
No,
lord.
actually,
Yes.
my lord, the money is
My lord,
already being deposited in the
my lord,
court below.
just I'll take, my lord, only 5 minutes. My lord, money was paid in the year 2003 to them, my lord. Now, while receiving the money from me, my lord, respondent number two, it gave me, my lord, the original document of a plot of land situated Beltala, my lord. And my lord, this present petitioner, my lord, present petitioner gave a declaration, my lord, that and along with 5, my lord, checks, that this money will be paid by these checks, my lord. Now, my lord, they are denying it. Thereafter, my lord, those checks were dishonored. These checks were now how they can deny, my lord, that it is not their liability. Both are hands in gloves, my lord.
At the time of admission of the petition, lordship heard the matter at length, and thereafter increment was passed.
No, my lord, both are sisters having their office in the same, and both are, my lord, family business, my lord. Both are family business of the same group, my lord. How, my lord, they made it dependent only to, my lord, delay that.
You show me where is the original decree?
Decree.
Page number?
This lordship will find at 64. This is an order, because this was a summary suit. Page 64, annex 5 of the revision petition.
ID card has not been received. That will.
No.
So this is the order.
Yes.
It was an expert decree.
Expert. And lordship will say the suit, summary suit at page 47. There are two parties. And the suit was filed by them, impeding the Ambalal properties as defendant in the suit. Page 47.
Copy of link 13.
Sorry. দুটা আছে নেকি 47 section 47 47 কি আছে
No, you say this respondent number 2 is the judgment debtor.
Yes, madam. Both are judgment debtor.
So how this judgment debtor can be a respondent in this CRP?
No, because yes, because he has not come up before this honorable court. Therefore, we have made them respondent. He has not
My lord-
come up before this honorable court.
my-
Only the
No. He's a decree holder.
decree holder is the respondent number 1.
My lord, just have a look
Sorry,
at my lord, page
he is a
68.
judgment debtor.
Decree.
Yes, 2 is also a
How
Decree,
can he be a
yes,
party?
petitioner is the judgment debtor
How can he be?
along with Ambalal properties, defendant number 2. Petitioner along with the Ambalal property, defendant number 2 is they are the judgment debtors. There are 2 judgment debtors. And one judgment debtor, yes, approached the honorable court. The other one, since he did not approach, so we have made them a party here.
No.
If their name is stuck off, if
Whether,
their name is stuck off, then also we do not have any objection.
pardon?
If their name is stuck off on the petition, the current petition, we do not have any objection. Only I am placing the record. Record says that school number 2 is not shot. Otherwise, I am ready. I'll place the matter before you also. And secondly, Lordship will see that last order. Last order, ready to action the matter.
Yes, honorable court state the operation of the court.
28-3. Yes. On that occasion, the matter was adjourned because of the fact that the affidavit filed by the respondent was not on record. 28-3. And we have also filed affidavit in reply. That is on record.
No, on that day, you have not pointed out that the notice upon the respondent number.
Yes,
two
we
is
did not
yet
know.
to be
Madam.
served.
After we searched the record, then it is up to your lordship.
Heard Mr. Katonier, learned counsel for the petitioner, and also heard Sir Blessing or learned counsel for the respondent. Office note dated 5/4/2025 indicates that service report upon respondent number 2 is still awaiting. Mr. Gore, learned counsel for the petitioner, submits that.
Respondent number 1, ma'am.
Or respondent number 1 submits that. This respondent number 2 is the judgment debtor. And he would not to have been arrived as a respondent number 2 in this petition. And only to cause delay in disposal of this petition while enjoying the stay of this stay order passed by this court on 18/9/2024. The aforementioned respondent, the judgment debtor is arrived as respondent number 2, and both are sister concerned and residing in the same
Building, my lord.
same building. And therefore, Mr. Gore submits that the interim order passed by this court dated 18/9/2024 may be vacated. On the other hand, Mr. Katonier, learned counsel for the petitioner, submits that he has no objection in the event of striking out the name of respondent number 2 from the array of this petition. And taking note of the submission of Mr. Katonier, the name of respondent number, it is provided that the name of respondent number 2 is struck off from the array of this petition at the cost and risks of the petition.
Risks of the,
Petitioner.
that risks are gonna take.
No, you have submitted it.
No, my lord. If they say that we are dealing the matter, then in that case, we don't have a reason to hear this matter today.
That's why.
That is my
your
at
at
the
the
risks,
cost and risks of you.
that is why the respondent two was made party only. Because of the fact that
you
he
argue
wasn't-
the matter now.
Yes, my lord. Definitely.
Mr. Khatuniya shall furnish the amended cost title before this court. The amended cost title on or before.
Amended. Or by hand, you can,
No, that cannot be. There is a process.
yes.
28 April. And taking note of the submission of Mr. Gore, learned counsel for the respondent number 1, and also considering the facts and circumstances on the record, interim stay pass hide order dated 18/9/2024 stands vacated. List the matter.
Without hearing me, my lord, then
So
let
we are
the-
ready.
let the matter maybe heard today itself.
No.
We are ready to,
No, you file cost title first.
my lord, then let it,
No.
my lord, let it be, my
No,
lord,
no.
let it be fixed earlier, my lord. The,
Next date we will hear the matter.
no, next date, yes, but instead of 28th of April, this would be fixed earlier.
Fiction?
Earlier date. Well, by that time, it may not become enforceable.
No.
Because lawsuit has passed the order after hearing it. Then lawsuit,
No,
I am
no,
ready
no,
to do the case today.
24. 24.
Item 13.
The matter will remain part.
Part 30,
Yes.
But this
Because
stay vacated. Stay vacated.
Manat,
Without hearing.
without Manat, then
No,
let me,
no,
let me
no, no.
make submission, Manat. Then the matter will become impossible.
Maybe. Whatever be the consequence. Interim order
Because-
vacated.
I have to place the matter, Manat, before the lawsuit.
You can place it on next day.
Yes, Manat, the matter will remain a part.
Yes.
13.
My lord, this is second appeal, my lord, that has been admitted by this honorable court on 2nd February 2025, my lord. But so far as the IA is concerned, my lord, this honorable court was pleased to issue notice. And accordingly, my lord, my learned friend has entered appearance.
No, whether appeal was admitted or not admitted.
Admitted by my lord,
Substantial question
by
of law.
by framing substantial question of law, my lord.
Yes.
There is an order dated, my lord, 2nd February 2024, 25, my lord.
Hmm.
There is an order, my lord,
Hmm.
formulating substantial question of law. Now, my lord, the IA number 277 of 2024, my lord,
Hmm.
which is pending, my lord. So IA is filed for under order. I am the plaintiff appellant, my lord.
Hmm.
So decree being agreed, my lord, by the judgment and decree passed by the Lord Munship, my lord. The respondent side filed title appeal. That has been reversed, my lord. Now I have filed this RSA that has been admitted. My lord, along with the RSA, my lord, I have filed one interlocutory application, my lord, for injunction.
Hmm.
Injunction, my lord, I am also claiming, my lord, that I am in possession of the suit land, that is a heart, my lord, where I am residing. And the defendant side, my respondent, and they are also in one part, my lord, that is admitted fact. But
Lordship, in the IA copy, we have not.
I have sent, my lord, they have entered their appearance.
Only RSA we have filed Vakalat Namal, Lordship. IA copy we have not received. Lordship.
So IA is the part of the
Yes.
RSA.
Yes, Lordship. Like, service we have not completed.
Service completed, my lord, sole respondent is there, they have entered their appearance. On the,
You have not received the copy of this IA.
Yes.
You want to file objection.
Yes, Lordship, we want file the objection.
You furnish a copy to her.
My lord, today
Let her
itself,
give us
today.
answer contest the case. Her is a P.U. Luster, learned counsel for the petitioner. Miss Dave.
R. Dev.
R. Dave, learned counsel for the respondent. Miss Dave submits that she has not been furnished with a copy of this interlocutory application. And as such, she prays that necessary direction may be issued to the counsel for the applicant to furnish a copy of this petition to her during the course of the day. There is accordingly allowed. Mr. Luster shall furnish copy of this IA to Ms. Deb during the course of the day. Deb submits that she may be granted some time to file objection in this case. Application period is allowed, necessarily submitted on. When?
After view vacation.
My lord,
After view vacation.
the date may be fixed, my lord, that is urgent matter.
Okay, take a date from him.
My lord, oblige.
Item 14.
My lord,
Early hearing.
my lord, yes, liberty was given, my lord, at the time of my lord admission. We registered, my lord, that is why, my lord, liberty was given. And this petition, my lord, matter of 21, my lord. My learned friend considered that it may be taken in the month of June, sometime in the month of June.
He has filed a petition for early hearing. So it's up to your lordship. May. Otherwise, matter is of 2021.
Mr. Sohan, learned counsel for the applicant and Madam R.L. Jadov for respondent. This application is preferred by the applicant for early hearing of the RSA number 52 of 2021. Ms. Jadov submits that she has no objection in the event of fixing an early date for hearing of the second application. Accordingly, it is provided that this is at least a matter of
Much.
5th of June. I close.
Item 16.
Lordship, learned counsel is out of station.
Acha. Who is the conducting counsel?
Mr. R. Islam. R. Islam.
R. Islam. It is a continuation petition.
I.
Yes, it is continuation petition.
Yes.
Let notice go then. Heard me, sir?
An alum.
An alum, learned counsel appearing on behalf of Mr. R. Islam, learned conducting counsel for the petitioner. The applicant. Its interlocutory application under section 5 of the Limitation Act is preferred by the applicant who continuation of 100 delay of 198 days in preparing substitution petition on account of the date of sole respondent, namely Vidas Malla Gorva. You are for the respondent.
Okay.
Okay. Let notice be put. Returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. That's a matter after 4 weeks. After 4 weeks.
For hearing, item 17 and 18, ordered matter.
They are supposed to give the list.
Lordship, on the last occasion, there was a direction to produce the copy of that cabinet resolution and the list. But I'm sorry, Lordship, the list contains 77 pages. So I have just forwarded the soft copy. I couldn't take out the printout, but the cabinet memorandum is there. And even I couldn't go through that list also. I have just received that list along with this cabinet resolution. So that copy I could take out the print because only hardly 4 or 5 pages. But the list contains 77 pages, Lord. Although I have
No, I was not asking you about the cabinet memorandum. I was asking
no,
you
this
about
itself
the
is a
cabinet
resolution.
decision.
This itself is an approval, Lordship, because the cabinet memorandum which I have placed before your Lordship, this is the one which has been approved. Because Lordship will file the
So where is that resolution approval of this memorandum?
that the signature of the principal secretary is here, Lordship. The Lordship may kindly peruse.
Maybe this memorandum was prepared for consideration by the cabinet.
And this itself was approved, Lordship.
Where?
Lordship may kindly peruse the last page. Signed by the principal secretary to the government of Assam. And Lordship will on the top will see the file number on the first page. File number EDM,
Which part of this cabinet memorandum it is stated that this memorandum is approved by the cabinet?
Lordship, it is an abstract. Lordship, the cabinet approval was for various matters. But so far as the illegal and irregular teacher is concerned, this is the memorandum which has been approved and the signature of the principal secretary is there, Lordship, and the file number. So this file contains the cabinet resolution in terms of various matters. So this is an abstract of that resolution which contains the matter pertaining to illegal and irregularly appointed teachers, Lordship.
You
How
show me where it is approved.
that signature is there, Lordship. Otherwise, cabinet approval sought as one-time exceptional measures for the following.
Approval sought and approved
Lordship.
are the same thing.
Cabinet gives it approval on 7th.
Lordship, see the forwarding letter.
Sir Sharma, don't try to be over smart.
No, Lordship.
You comply with the direction of this court.
Lordship, just see the forwarding letter. What they have stated here. I am directed to submit here with a copy of the cabinet resolution and the list of incumbents under illegal, irregular category teachers who were accommodated as teachers 1149 and
You show
tutors
me the
3.1.
resolution. Where is the resolution? Because this letter will not convert this memorandum into resolution.
Lordship, in that case, Lordship, I will, because the one which they have furnished itself is a resolution, or is there any approval is there? I asked for the approval also, but I have been narrated that this itself is an approval because there is a signature of the principal secretary. That particular point
Who
I
will believe it? Who will believe it that this is the cabinet resolution?
Lordship will fix the day after tomorrow, Lordship. I will clarify. I will ask them to send the approval letter. Otherwise, Lordship may. In that case, I will place the hard copy of the list also. Because I have to that particular point which your Lordship has raised on the last occasion, that I asked them. I asked them whether this itself is an approval. Where is an approval? That the similar question I raised before the department, the joint secretary replied me, because this memorandum contains file number so and so, and there is a signature of the principal secretary, and this itself is a resolution, a cabinet memorandum which has been approved. This I have been told. I am not saying of my own, Lordship. I have, on the basis of the instruction I have received, I am submitting before Lordship.
No, you are not supposed to act like a post office.
Lordship, otherwise then.
Since they have conveyed to you and you have conveyed it to the court,
Lordship,
that is
Lord-
not your function.
Lordship, Lordship. Or immediately
Let the
after.
matter day after tomorrow, so as to enable Mr. Sharma.
On 11, Lordship. On 11.
Lordship, they can give this in the court master and the Lordship mail, Lordship. List, Lordship has asked for the list of Sivsagar district by illegal and excess teacher and the cabinet memorandum. They can give to the court master also by mail.
Not memorandum.
Resolution.
Let them produce it. Let them produce it. Because if I fix the matter for this judgment, I'll be in difficult to write the judgment. Because the clarification who is being sought from him, he is unable to clarify it. He even do not understand what is cabinet resolution and cabinet memorandum. So as to enable Mr. Sharma to produce the cabinet resolution in respect of the cabinet memorandum dated where the date is mentioned in this memorandum.
The date is also not there. The approval part is there, due department. In fact, the approval was made on 7th of October 2020. That very date is not there. Lordship.
It bears no date also. In respect of the cabinet memorandum prepared. About the number of officers. In list 1 and list 2. Before this court on 11.
Publish.
List the matters as parted.
List 1 and list 2, Lordship.
Add 2, Lordship. Document is add 2.
2 p.m.
Publish.
Items 19 to 22.
May I please? My lord, in the meantime, I have collected some relevant documents, my lord. I just want to clarify, your lordship, if once peruse, my lord, will be clarified with regard to the promotional benefit and the special pay. Just I want to place some documents with some explanation I have given. The benefits of special pay, my lord, your lordship will find the document number 1, order of in charge headmaster.
This instruction is produced by you.
Lordship.
And what is this instruction?
Lordship, director wrote the letter to the secretary, government of Assam, and instructional awaited in this regarding the 3% of promotional increment.
This is, yeah, just your lordship may take up this, my documents, my lord. I
No,
will be-
that's all right. Why this letter was written on 5th of April? Why not earlier?
They have filed their affidavit, cases in the hearing stage. At the stage they are writing a letter. And I have submitted documents, my lord, which will show the benefit of special alliance is given to all, irrespective of the whole promotion. Promotional benefit is different. though all these memorandums are issued, notifications issued under ROP 2017, but the implications are different.
So, by this letter, the director has asking the secretary to the Department of School Education regarding allowing 3% promotional increment to the teachers who are promoted to the post of headmaster with equal pay band and grade pay. So, can we grant them some time to comply with this?
Yes, your lordship will grant them time because the instruction what will come from them, it is in the form of impugned speaking order. It is there. Impugned speaking order which is put to challenge here.
No,
In that impugned speaking order, they have already expressed their opinion that we are not going to give them 3%. That is why it is put to challenge.
No, that's all right. But now they have again moved the matter.
Yes.
It is in the process.
Yeah.
Perhaps we should wait for some time.
Yes, I have no objection, my lord. Just before that, my lord, I will just want to point out some documents I have given. I just will clarify your lordship something. Your lordship will find the document number 1 is the in charge order in respect of an LP school, my lord. LP school teacher has been given the headmaster. There is no post of head teacher, sanctioned post of head teacher in LP school. All are assistant teachers. This is the order whereby he has been given the charge of the, at page number 1, my lord, he is given the charge of the LP school headmaster. But in next page of document number 2, your lordship will find this is his pay slip. Your lordship will find 300 rupees. LP school teacher getting 300 rupees. The special pay I have given. Special pay is 300 rupees. Without promotion, this is given. And my lord, thereafter I have given the 2 service books of 2 teachers who have been promoted to the post of headmaster from science graduate teachers. Your lordship will find at page number 6 that after and before promotion, scale of pay is same. Amount of quantum of salary in the basic pay structure is same. It's a mark, my lord. Page number 6. Without any benefit. 46310 and 46310 before promotion, after promotion. Same as in the page number 9 also. 46310, 46310 in respect to another teacher, science teacher, no benefit. Thereafter, I have added, my lord, page number 10, annexer document number 4. This is the, my lord, the order that your lordship asked them to take the instruction that one of the petitioners has got the benefit, my lord. And I take your lordship to page number 12, document number 6. This is the fixation of one arts graduate teacher serving in the ME school who has been promoted to the post of headmistress. Your lordship will find existing pay band 14,000 to 49,000. Existing grade pay 8,700. Existing pre-promotional basic pay 39,720. This is after adding basic pay and this pay band. Existing pre-promotional pay in the pay band 31,020. Then your lordship will find pay band in the promotional post. It is also same from 14,000 to 49,000, and grade pay in the promotional post is also same. It is 8,700. Then in the next column you will also find 1A. Fixation of basic pay on the date of promotion. Add one increment at the rate 3%, pre-promotional basic pay to the existing promotional pay in the pay band as per rule 11(1)(a). This is, my lord, that amount 31,020. This has come from the earlier basic pay, total basic pay. Your lord will find And over that, my lord, 3% has been calculated as 1200, and that is added 32,220 as basic pay. That is, my lord, pre-promotional and after promotion, same payment and same grade pay. Arts graduate teacher has been added the 3% benefit. It's a promotional incremental benefit. This is the fixation. Thereafter, my lord, another fixation, whatever it is given, pay is fixed. Document number 13, my lord, it is the undergraduate teacher of the arts graduate MA school teacher, undergraduate teacher of MA school, who has been promoted also to the post of headmaster. His salary is also fixed at the rate of 3% after promotion. The lordship will find at page 13.
Page number
13. Document number 7, page number 13. His grade pay was 6,800. Because he was not graduate, therefore his grade pay was 6,800. And my lord, his fixed salary was 31,680. And my lord, his 3% added below that, my lord, a fixation after it is, my lord, 38,480 into 3% equal to 1,160. It is added with the salary as a basic salary, my lord, and he has been also granted the benefit of 3%, who is not my lord, graduate at that point of time. Thereafter, I take your lordship page number, document number 8. After page number 14, there is a document number 8. This is the finance department, my lord, FinAssam generated statement. This all employees are paid through this only portal. Your lordship will find after basic pay, this person is getting he has already got the, my lord, benefit of 3% in the increment, and the basic pay is also added accordingly. And your lordship will find the special pay, 300 special pay is given. After basic pay, 300 special pay. Grade pay 8,700, basic pay such and such, and 300 special pay is also given. Both the benefits are given, special pay as well as the incremental benefit. It is not that this special pay is given, so we are not entitled for the promotional benefits. This cannot be the case of the respondents, my lord. And my lord, I take your lordship thereafter. Another headmaster of the page number 16, my lord, and document number 9. This is also filed, another arts graduate teacher. He has also got the basic pay, it's a promotional benefit as well as 300 basic pay. Pay slip generated from FinAssam. Latest pay slip, February 2025. 300 basic pay. Thereafter, I take your lordship to the page number 17, document number 10. It's a fixation in respect of a high school teacher, because the special pays are for all categories. Your lordship will find one teacher has been promoted to the post of headmaster in high school, my lord. After fixation, after promotion, his salary has been fixed and he has got the benefit. And also the same person is given the 300 benefit.
Mr. Katonier, so it appears that some of the teachers have been given this 3% benefit.
That is why, my lord, director has wrote a letter to the government, my lord,
Yes.
seeking instruction, my lord.
So when can we expect a reply?
Immediately after BU vacation, my lord.
Immediately after.
Yes, my lord.
Okay, let them come with the reply. Or Mr. Professor, learned for the petitioner, and Mr. Katonier, learned standing counsel for the respondent elementary education department. During the course of deliberation, Mr. Katonier has produced a letter of the Director Elementary Education dated 5th of April 2025, written to the Secretary of Assam, seeking instruction in respect of allowing 3% promotional benefit to the teachers who are promoted to the post of headmaster with equal pay band and grade pay, and submits that the matter may be listed immediately after reopening of the vacation, so as to enable him to apprise his court about the latest instruction, which is supposed to be received from the Department of School Education. Accordingly, it is provided that list the matter on February 6th of May.
Yes, madam.
Yes,
The letter produced by Mr. Katonier shall be part of the record. And a copy of the same be furnished to Mr. Pujas.
Yes, my lord.
As parted, my lord. As
They are already
parted.
parted.
Yes, recessal list the matter as parted.
Obliged.
Yes, Mr. Talukdar.
My lord, over telephone, I have received instruction that, my lord, at the time when the order passed, my lord, at the time of order, my lord, the post is petitioner is not in he is in service, but the post was not as he is a illegal and irregular
No,
teacher.
no, thereafter this supernumerary post was created
Created,
and
my lord, in the year
salary was paid to him.
2012, my lord. After the original, my lord, writ petition, my lord, WBC 188 2013 order passed. Then the, my lord, 2015, my lord, the supernumerary post was created, my lord. And at the time of, my lord, as per my instruction, my lord, at the time of his order, my lord, your lordship query, my lord, and that the post is not in existence.
No, no, they have created a supernumerary post.
My lord,
Earlier, what happened to those supernumerary posts?
so lordship, I pray, my lord, lordship may pass an order, my lord, indicating the query and fix it immediately after Bihu vacation, my lord, so that I can.
No, no, no. We'll draw up about some other contempt against the director and the secretary. You comply with the order, you release the salary.
If after not satisfied with the instruction, my lord, immediately after vacation, my lord, then lordship may pass any order, my lord. So today I received from the government side, my lord. I tried, my lord. I could not reach, my lord. But director office, from director office, I gathered this information, my lord. So, and the director office, from director office said that it is under the government, my lord. So lordship, just for 15 days, my lord, after 10-15 days, my lord. Just for, I pray for 10-15 days, my lord, after immediately after vacation, my lord. So lordship may indicate
Okay,
that.
okay. Third, Mr.
S.U. Ahmed.
S.U. Ahmed, learned counsel for the petitioner, and Mr. B. Talukdar, learned standing counsel for the
Elementary
respondent in elementary education department. And he does for respondent number 5. Respondent number 5. And Soliha, you are here for respondent number? Mr. Soliha for respondent number 4. During the course of hearing, Mr. Ahmed, learned counsel for the petitioner, has drawn attention of this court to an order passed by this court dated 28/4/2027 in WPC number 3628 of 2016, and submits that in the said order, this court was pleased to issue direction to the respondent authorities to pay the salary of the petitioner, salary and allowances of the petitioner from March 2015 till date, which should be considered construed as arrear salary, and the current salary henceforth shall be continued to be paid till a decision is arrived at, and the respondent shall also pay the salary from February 2015 till date. But the respondent authority has not preferred any appeal against the aforementioned order. and also not referred any review petition. And the said direction of this court has not been complied with till date. In view of the
Fundamental
aforementioned
detail.
facts and circumstances, Mr. Talukdar, learned standing counsel for the respondent authorities in elementary education department is directed to obtain instruction as to why the aforementioned order has not been carried out and why any further action should not be initiated against the respondent authorities. List the matter on 21st.
22 Lordship.
21st.
Lordship may,
As part of
Lordship may indicate the annexer 12, my lord, supernumerary post created.
No, that is with you. You consider it?
Lordship, can it be 22 Lordship? Can it be 22 Lordship?
Okay.
It's okay. Okay. Okay, to 21 Lordship.
Okay.
Mazhab.
Apply.
Item 26.
May I please your lordship?
Yes.
My lord, I am the legal
Counsel.
aid counsel.
Yes.
My lord, the learned Munship number 1
So,
issued
who
a
is for the respondent?
respondent, your lordship earlier date already absent, and my lord, this respondent name is APR.
Respondent.
Earlier date appeared, my lord, due to leave application, this honorable court, my lord, give time, my lord. Subsequently, date was fixed to date.
Heard Mr. Z. Hussain, learned legal aid counsel for the appellant. None appears for the respondent on call. List the matter on 20.
15 May.
15 May. Sorted. Okay. 13th of May. In the event of non-representation of the respondents on that day, appropriate orders will follow.
My lord, matter maybe, my lord, matter is simple, my lord. The expertise order passed, landed Munship number 1, the expertise degree in favor of the plaintiff, that is myself. Subsequently, my lord, this respondent filed the first appeal, and first appeal set aside the landed Munship
That's all
number
right,
1.
but the other side is not present today
Well, Pathak,
to keep the matter as parted.
my lord, earlier, my lord, so many date, my lord, the learned, my lord, respondent is not appear, my lord.
On next set, if the respondent remain absent, we will take it.
Pathak maybe.
No, no, Parthat.
27 and 28.
Obliged.
So both the parties are represented.
Yes.
Yes.
So ready for hearing.
Yes. So it's a very old matter, my lord. 2018 judgment has been passed, my lord. There is no stay order, my lord. And my lord,
2019.
yes, my lord. Judgment is of 2018, my lord.
Mm.
The appeal has been preferred in 19.
Mm.
There is no stay order, my lord, operating, my lord. No interim payment has also been made, my lord.
Could have filed on IA for issuing direction to the appellant for releasing 50% of the amount.
Anyway, your lordship may decide some, my lord, issues.
Yes, madam.
Lordship, this is an injury case.
Jury.
Injury case.
Both the matter.
Both the
The other
matter. One
matter
we
of-
have
the
filed
counter,
and
counter.
another they have filed. The claimant has filed the second one.
We have
They have
applied
filed
for
for
enhancement of interest.
enhancement.
And,
Okay.
and we have filed for reduction. If Lordship wants, then we can do it after Bihu vacation next day itself. If Lordship is not.
No, 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 no.
Oh.
I have no other case today.
Okay, then
We can
do-
hear the matter.
Okay. Lordship, should I read the judgment or should I go to the points?
Not necessary. You directly come to the point.
Points.
Yes.
Yes, Lordship.
The
Lordship,
grounds of
yes. We
filing this appeal.
Yes, Lordship. First of all, Lordship, there was no FIR, GD entry or anything on the date of accident. After 10 months of the accident, case was filed in the court and then only the motion started. It is important. Why it is important? Later on, I'll come to.
No FIR and GD entry.
No FIR, no GD entry, Lordship, on the date of accident.
Next.
Then next we have taken, Lordship, the major important is that Exhibit 70 was the disability certificate, Lordship, based on which the court came to a conclusion.
Exhibit 17.
Exhibit 70, 70.
70. Okay.
Disability.
70. Disability certificate issued by?
Issued by the board. But Lordship, in that certificate, there is no mention of any disability.
Okay.
It is.
Where is the certificate?
Lordship will find that Exhibit 70 at page 73 in the LCR.
This paper book is prepared.
Paper book, I don't know, Lordship. LCR, page 73. But the LCR, Lordship, it is jumbled up.
Look, we have prepared one paper book.
সেইখনৰে কথা কৈছো, মোক দিয়া নাই। নাই দিয়া। নাই মোৰ তাত। মই সেইকাৰণে LCR ৰ পৰাই চাইছো।
Exhibit 70. 17.
No, 70, Lordship.
70.
দেখুৱাই দি আছো। Lordship got it. In the LCR, it is at page 73. LCR is also jumbled up, Lordship. Some pages are front and here, but 73 is the page of the disability.
Okay. Got the disability certificate. Name is Parthapratim Hazarika.
Parthapratim Hazarika. Lordship will find that he is physically disabled due to multiple contusion in left basifrontal part of right occipital. So these are all injuries. Lordship will find these injuries in his hospital record, Lordship. That
no, madam, you come to the last line. 70% permanent disability, loss of income 80%.
Yes, Lordship. But Lordship, what is the disability? These are all injuries which were mentioned in the hospital.
If they have not specified it to a particular line,
yes,
then it has to be. It may be in relation to his whole body.
No, Lordship, these are all connected to occipital, midbrain. This is all head, Lordship, not full body. These are the injuries, Lordship. Those injuries I'll show, Lordship. These are exactly mentioned from this because the doctor who proved this disability certificate, Lordship, he neither treated him nor he has signed the disability certificate. He said so.
Where is the evidence?
Evidence.
Of this doctor?
Evidence, Lordship. Doctor cross 70 backside is the cross. Page 70 backside in the LCR law.
Vikas Ranjan Gogoi. Yes.
Vikas Ranjan Gokul.
Yes.
I'll read, Lordship. His chief, I have appeared before the court after receiving the summon to depose evidence, as I am authorized to depose evidence on behalf of Joint Director of Health Service, Nogam. On 19/2/2018, while I was working, Lordship will mark this date because the accident took place in 2008. Date of accident is 2008, but the certificate was issued after 10 years of the accident. Date of accident is 12/10/2008.
Accident took place on
12/10/2008. That means 12th of October 2008.
disability certificate was issued on 19/2/2018.
Yes.
Yes.
While I was working as SDM and HO Nogam headquarter, on that day, the medical board under the chairman of Dr. A.C. Patar, Joint Director of Health Service, examined the person, namely Parthapratim Hajarika. He was found disabled for causing multiple contusion in left basifrontal, right occipital, midbrain, left temporal, and left high parietal region following RTA on 12/10/2008. Lakship, see? 2008 the accident took place, and this doctor is finding this disability in 2018, which mentions only the injuries that he suffered. I'll show the medical document also, Lordship, of GNRC, which mentions these injuries. The doctor, they have not said a disability of which part. If it is locomotor, it is that has to be mentioned, Lordship. He was found 70% permanent disability and loss of income of 80%. I examined the person physically, clinically, and after perusing the pathological reports. Exhibit 70 is the disability certificate, and Exhibit 71 is the signature of Dr. A.C. Patar, the Joint Director of Health Services. Something is missing. I think, chairman of District Medical Board, which is known to me. Exhibit 71 is the authority letter given to me to depose evidence by the Joint Director of Health Service, Nogam. Exhibit 71 is the signature of Dr. A.C. Patar, Joint Director, Health Service, Nogam. In cross, he says, I have not exhibited the application submitted by the person Parthapratim Hajarika for assessment of his disability by the board. As per report produced by us, the person has sustained injury on 12/10/2008, and he appeared before the board on 19/2/2018. It is not the fact that the disability does not arise due to sustaining injury at the time of alleged motor accident, as he appeared before the board only after 10 years from the date of alleged accident. I am not an orthopedic surgeon. It is not a fact that the assessment was not done as per WC Act. I have not signed on Exhibit 70. It is not the fact that I was not present at the time of examination of Parthapratim Hajarika. I did not treat the person after accident and before examination by the board. These two things, Lordship, are important. I have not signed Exhibit 70, and also I did not treat the person after accident before examination by the board. It is not the fact that the assessment made by the board regarding the percentage of disability and loss of income is not acceptable. Lordship, this evidence I will later on show Rajkumar and Ajay Kumar judgment, Lordship, how the doctor who came to exhibit the document, he has neither treated nor he has signed that document, Lordship. He adduced evidence.
No, not treated, but he has examined the person concerned.
Lordship, that is what he is saying in chief, but in cross he says I have not. No, I did not treat the person after accident and before examination by the board. Yes. In chief, he is saying that is demolished in cross.
No. He in chief categorically stated that he has examined the person physically,
that is
clinically, and after perusing the pathological report.
That is in chief, he is saying, Lordship. But in cross, that is demolished when he says, I did not treat the person after accident and before examination by the board.
Treatment and examination are two different things.
No, treat the person after accident and before examination by the board.
No.
The earlier line, my lord.
It is not a fact that I was not present at the time of examination of Parthapratim Hajarika. Earlier line is that. Before that, I have not signed on Exhibit 17.
No, maybe.
I did not treat the person. But Lordship, Apex Court in Rajkumar Ajay Kumar very clearly says that the doctor who adduces evidence should have treated the person.
No. That is not the.
I'll read that, Lordship.
Because this is the board who has issued the certificate.
The board member did not. He has not. The doctor who came, he has not signed that certificate.
No, under authority he appeared.
Maybe under authority, Lordship, but after 10 years, how they are, matching that, Lordship, how they are matching the gap of 10 years. That this was the
No, if the disability is permanent disability, it will continue till his death.
But Lordship, after 10 years,
No, it is not the case that the disability is temporary.
But disability of what, Lordship?
Pardon?
Disability of what? In disability certificate, Lordship, in other cases, we find it is mentioned, it is locomotor disability or whatever disability. Here, disability.
Particular line has not been mentioned, but it is in absence of such a specification, we have to consider it covering the whole body.
Lordship, how come the injuries are of the head? How come the whole body? Because those, Lordship, that is totally copied.
The head control the entire body.
No, Lordship, the Lordship, this GNRC report is there, Lordship. GNRC registration card, Lordship, that Lordship will find at page 7 in the LCR.
Page
7.
GNRC?
Yes, Lordship, they have given one
certificate.
Not certificate, his injuries, about his injuries, Lordship. Discussion and management, Lordship. Second page. First page is
exhibit.
That is exhibit 4, I suppose.
4.
4. Cutting is 4, no? 4.
Yes.
The next page, Lordship. Discussion and management. Lordship got it. Mr. Parthapratim Hajarika present with HO road traffic accident on 12/10/8 followed by LOC at admission his GC something. Lordship revealed multiple confusion in left basifrontal, right occipital, midbrain, left temporal and left high pericial region, subarachnoid hemorrhage in left pericial region. Lordship, the same wordings are Lordship will find in the disability certificate. The injuries, Lordship, disability certificate mentions where is the disability, not the injuries. Same injuries are mentioned in the disability certificate. Exactly same injury. And after 10 years.
And what are the other points?
Other points, Lordship, I'll go to the exhibits itself, Lordship. I'll take one by one the exhibits. Exhibit 12. Exhibit 12, Lordship, I find the date to be 2006. Why I'm bringing it up, Lordship? Because I'll show other documents.
Exhibit 12.
Yes, Lord.
Yes, exhibit 12.
The date Lordship 15/10/2006. 8/6/10 যি হওক মই বেলেগ 6ত লিখবা
1610, yes.
15/10/2006. It is 15, I suppose.
Yes, exhibit 12, yes.
Yes, Lordship. Then 13 is bed number 1510. 14 is also that. 15 again, the bed number is changed. Same date, but the bed number is changed. Lordship will find 15, and if we compare 15 and 16, Lordship, 1104 bed number, and in 16, 1510. These are same date, Lordship. 18 again, 1104. Then again on 18 itself, 1107.
No, maybe bed number may be different. They may change the bed number. But does it raise
Lordship, what I'm
suspicion
trying to
about,
show, Lordship, what I'm trying to show is whether the claim itself is genuine. I'm coming to other documents also. Exhibit 26, there is no date. Then Lordship will find Exhibit 27. This is relating to one Deep Hajarika. 28 also. 29 also. These are relating to some other person, Lordship. There is no date, nothing.
no, this is only one advice slip.
Lordship, they have exhibited it as the document of the
But
Parthapratim
have you
Hajarika.
put any question to them at the time of examination in chief of the exam cross-examination of the claimant?
Lordship, it is not a question of cross-examination by the
Unless you unless you challenge it before the trial court, how can you challenge it in the appellate court now?
Lordship, because Lordship will look into the exhibited
That's all right,
documents, the evidence.
we'll go through it, but unless you put any question, unless you disputed the document before the tribunal.
I'll come to the cross-examination, Lordship. First
Yes.
of all, let me finish the documents, Lordship.
Then
Lordship, Exhibit 34.
No,
Fraud, Lordship, if someone
even,
commits.
Even we discard this exhibit 27, then how it will affect your case?
Lordship, it will affect Lordship. Let's come to Exhibit 34. Because Lordship, if fraud is committed, Lordship, any court, any tribunal can at any point of time take up a. Lordship will find the date. Lordship got it, Exhibit 34.
Yes.
Lordship, the date and time of this this expenditure voucher, Lordship, because this is calculated 13 October 2006. Lordship got the date.
Yes, the accident took place on 12/10.
12/10/2008, Lordship. This is of 6, even before the date of accident.
Pardon?
This is before the date of accident.
No. Accident took place on 12/10/2008.
Yes.
And this document is of the date 13/10/2008.
2006, Lordship.
No,
Date
no,
and
8.
time. Lordship.
34, you see the case memo. Thereafter the date. 13/10/2008.
Lordship, cash collected by Biren, date and time 13 October 2006.
Maybe.
Oh, it was a data set into A2 at a data set.
But you are only pointing out one date.
Huh?
Lordship,
Madam, you see the date?
and Lordship down below the date, 13, just after 2 lines from that, Lordship, cash collected by Biren, date and time, 13 October 2006.
Maybe there may be some, but date is clearly mentioned.
No, that date is mentioned, Lordship. If these are manufactured, Lordship, the cash collected Biren, date and time is 13 October 2006. And not only this document, Lordship, other documents are there. Next document also, Lordship, 36. In exhibit 36 also, it is 13 October 2006. Print date. After that, 37 in every document, Lordship, 37, 38, 39, 40, 41.
No, in 35 also you see the date is 13/10/2008.
Lordship, that date is mentioned, but there is a print date.
Hmm?
Print date, when it was printed, the cash memo. Print date is there, 13 October 2006. In all the documents, Lordship. Okay. 8, 49, 50, and also 51. 52. All these, Lordship, print date is given that. Though the date above is written to cover the date of accident.
No, if it is not corrected by the person concerned in the system, then definitely this will be uh, wrong on their part. But the other date is mentioned as 15/10/2008.
Lordship, then let's come to exhibit 57.
Exhibit 27.
57, 57.
57.
This is the interim bill, Lordship. Run date 23 October 2006. Then same exhibit, Lordship, next page, statement of account of the patient as on 23 October 2006. তাহলে next page. 57 to continue আছে তোমার হেৰি interim bill খন continue হৈ আছে. Then also 58 also 2006 is mentioned, all these still. And Lordship, 61 is, I think, sale and return. This amount was returned. But the court has taken all the, has calculated as per their own calculation, has added all these, the amount which was also returned. And these are all 2006 print date. Then Lordship said that there might be some mistake. Lordship will look at exhibit 64. Here there is a correct date. And the same is in exhibit 66, Lordship. Correct date. If it was a system mistake, Lordship, then these document would also have shown 2006.
Okay, now come to the cross-examination of the PW1.
That 9 আসলে যদি ভিতরত আছে। চারশো হলেও হবো। paperwork format. I do not know about criminal case GR case number 88209 in Jagirod PS case number 184 of 09. I do not know if the owner driver was acquitted or not. I have not submitted.
So it means that case was registered.
No, yes, case was registered after 10 months because they filed a application for the
Solicited.
CGM.
It was solicited.
Charge sheet too, I do not know. They exhibit.
Therefore, the case is GR.
Charge sheet is still making. Because they filed a petition before the CGM court, a complaint case to register the case. And then the process started. But on the date of accident, there is no FIR, no GDNP.
Maybe. Oh, you have not put any single question about the vouchers?
Lordship, vouchers, the court will look into the vouchers, Lordship.
Pardon?
The court will look into the, because this is an
Definitely,
inquiry.
Those vouchers were exhibited before the tribunal.
Yes.
Then you have not disputed it. You have not pointed out the discrepancies and asked any question to the claimant that why this that is so and so, so and so.
Lordship, that I think the court will also look because tribunal, MSc tribunal is a inquiry tribunal, Lordship. The court cannot just.
Definitely.
Uh,
But cross-examination is the duty of the this respondents, no?
That is true, Lordship. They have put some question. I have not submitted any.
You cannot compel the court to put some question.
No. I'm not saying they have put some question. Mane, I have not submitted any document with regard to my income or regarding proof my salary. I have not submitted any document to prove my disability. He has said that. I have not produced any document to prove my conveyance expenses from Nagaon to Guwahati while being transferred.
Which line you are reading?
Lordship, I think this is typed copy.
Yes.
I think 115. It page it may be that. I think Lordship will find at 115 page. The paper book they have prepared, Lordship.
Paper book. Yes, 115.
Yes, Lordship.
Yes, I do not know about the criminal case.
Criminal case GR case number 88209 in Jagirod PS case number 18409. This is the case they had given. Lordship. I do not know if the owner driver was acquitted or not. I have not submitted any document with regard to my income. No one came from Vertex company regarding to prove my salary. I have not submitted any document to prove my disability. I have not produced any document to prove my conveyance expenses from Nagaon to Guwahati while being transferred Guwahati. Then OP5, I have come from Nagaon by bus. The accident happened due to sole fault of the scooter. I claim compensation from the owner of scooter. After 18/1/14, I have not filed any medical document. Exhibit 2 shows that the accident occurred due to rush of scooter. Then Lordship, let's come to the compensation given by the tribunal. There is another cross-examination, Lordship, at page 119. I didn't file any Ejahar FIR after the accident. It is not a fact that the accident occurred due to my negligence, not for the negligence of scooter. I was working under, because Lordship, there was, admittedly, there was head-on collision. The court has not taken that also into account. I was working under Pankaj Tamuli. After the accident, Pankaj Tamuli lost their patio. দুবার হয়েছে।
ক্লোজ হয়ে গেছিল তারপর এক্সপার্টি হয়ে বসলে তারপর রিভিউ করলে তারপর
Achha. It is not fact that the insurance company of the scooter falsely involved in the case. I have not furnished any income certificate. It is not fact that I have no income source. Doctor is not produced today as a witness. Currently, no document has been furnished of my treatment. For the last time on 18/1/2014, I went for checkup. It is not fact that I did not become permanently disabled. It is not fact that rupees 2 lakh has been spent for my treatment as I could not furnish all the documents. It is not fact that any supportive prescription have not furnished against the cash memos. This is our Lordship. It is not fact that I am not eligible to be compensated in terms of my rate. It is not fact that the bills for the return memo are acknowledged. Crossed by OP5 on point of disability certificate. It is not fact that I have not suffered loss in my income due to my disability. It is not fact that I am not 70% disabled as mentioned in the certificate.
We now come to the finding of the learned tribunal.
That's it. Tribunal, page 19 of my memo of appeal or internal page 12 of the judgment.
12 of
Judgment, Lordship, or page 19 of my memo of appeal.
Yes.
Lordship, straightway without any calculation, the court says for disability and loss of estate 5,37,600. For medical treatment 98,363. For pain and suffering 50,000. Lordship, go ahead.
Disability and loss of estate.
Hmm.
Uh,
There is no calculation, nothing.
okay. Medical treatment 98,000. Pain and suffering. So when this judgment was pronounced?
Pronounced on 21 December 2018.
18. In the meantime, this Rajkumar's judgment was there.
It was there. Rajkumar is 2011. Lordship.
11. Yes.
So totally, it
So
can be
the
remanded by
formula-
Lordship. It can be
Formula
remanded.
laid down therein.
Lordship?
The formula laid down therein has not been followed.
No. It can be remanded back so that proper calculation, because they have also filed a and time frame can be fixed, because only the calculation part will be there and the court can.
Madam, this is the first appellate court. If we remand the matter again, somebody went to the goes to the Supreme Court and the Supreme Court will review that.
No, Lordship.
First
For
appellate court.
calculation, Lordship, Gola Ranjana is there, where the apex court said that the trial court is the best place to, Gola Ranjana, of course, I haven't brought right now. Trial court is the best place for making the calculation. Lordship can fix a time frame within this 2 months.
No, we can calculate carried out the calculation here. In view of the formula laid down in that case, that's more like.
But Lordship, then Lordship will look into the documents also, the medical expenditure.
Definitely. And this evidence has also to be appreciated. Yes, Mr. Dubey. So do we remand the matter or we shall undertake the
My lord may
process
do
of
it as an appellate,
calculation?
first appellate court, my lord.
Pardon?
My lord may do it as a first appellate court, not the calculation part of it. But so far as the documents which my learned friend has shows, my lord, what I see is there is a runtime error as regard the printing. For a moment, if you lost the exhibit 27 for a moment, if you lost it here.
27 to the Deep Hajirika.
No,
Belagar
no,
Nagar.
that's a separate one. No.
27 to 22.
As regard the timing, 34. Lordship finds at page 79 of this
Paper book,
paper book.
79.
Yes. Let's see at the left hand side, this is the date.
13/10/2008.
Yes. And on the right side, this is 13/10/2006. Exactly 2 years gap so far as running. Because at times printers are set a default, but which shows the run time. My lord, see the timing also they say when it was printed. And similar is the case in other MLOD exhibits.
No, maybe, but in cross-examination, this
Nothing has been
questions.
nothing has been asked, Lord. Friend has shown you Lordship's MLOD's exhibit.
Okay, Mr. Dubey, let Ms. Mazumdar to complete it.
Yes, yes.
Madam, any other point?
Yes. Then there was head-on collision. Admittedly, there was the injured were also driving a vehicle. So that has to be as per Dukkar case.
Whether the other vehicle was a party here.
No, other vehicle because he himself was driving, but the insurance was party. Oh, no, United Opera. Oh,
Yopa? Respondent number 5.
Owner. So they were
United
party.
India. Okay.
They were party lordship.
No, they were party, but was there any finding of the tribunal that there was head-on collision?
No, the case itself was that person. Not head-on, from behind.
Okay.
Then lordship, I've already said about the granting of that calculation. No, without calculation, the amount is given. Lordship. And exhibit the exhibit 70 lordship does not fulfill the requirement of section 142 of the MV Act.
Exhibit
70, the disability certificate. Because there no disability is mentioned, only the injuries are mentioned.
It is not in consistence with
Section 142 of the MB Act 1988.
section 142.
Yes, sir.
The old MB Act.
Yes, lordship. Because this was during that time only. Lordship.
Okay.
And I already mentioned that the exhibit 70 disability certificate was issued after 10 years. The doctor also exhibited. And also the treatment, he himself in his cross-examination said that after 18/1/2014, he has not taken any treatment, lordship. Not taken any treatment after 18/1/2014, but the disability was issued on 27/2/2018 with the injuries mentioned. Already I mentioned that PW3 clearly stated that he did not treat or sign the document, lordship. Rajkumar Ajay Kumar is very clear on that point.
Okay.
Then lordship, the case was filed in the year 2011, but only on 1/10/2018, after 7 years, the claimant adduced evidence, but the learned member has given interest for all that time also. After 7 years, the evidence was adduced.
Okay.
And as per the own evidence cross-examination of the claimant lordship, his he has not proved any occupation or income. Nothing is proved. I read that.
No, sir, he somewhere deposed that he is working in Vertex.
But no evidence was, he has not produced any evidence on that.
Yes.
Working, he did not exhibit. কোনো exhibit করা নাই। নাই। There is no exhibit, no working.
Income.
Not only income, occupation also. Though he said that he was working there, he has not given any employment, appointment letter or anything.
Okay.
On his appeal lordship, after he does, if there is any necessity, I'll give a reply.
Pardon?
That is my submission, lordship.
Mr. Dubey.
But so far as the receipts are concerned, Lord, there are two dates appearing in your lordship as in Lord.
No, what are the grounds for enhancement?
Lord, rate of interest is only given 6%, Lord.
Rate of interest 6%.
Which our cases, Lord, on rate of interest.
Rate of interest 6%. What was your claim?
But my claim was it ought to be, Lord, higher 9%, Lord.
Idea interest. Interest mention করা নাই।
Mention করা নাই।
Okay, what are the other points?
But we have in our appeal memo, Lord, where it said that it should be 12%, Lord.
12%.
Yes.
Your claim was for 12%.
Yes. And Lord, so far as our income is concerned, it should have been taken at 6,500, Lord.
How? And why?
Lord, basically, Lord, though materials were provided, my Lord. Lord, no salary slip or evidence as such was provided, my Lord.
Then?
But
it's a notional income.
My Lord.
Notional income.
Notional income. Lord, while granting Lord, his future aspect of earning should also have been considered, Lord.
Future prospect.
Yes. Lord has seen so far as certificate is concerned, my Lord. But I am relying on a judgment of the apex court, which has even accepted a disability certificate after 20 years, my Lord.
What do you say?
My Lord. Arbitrage, that should be the- My Lord will take that 2022 8 as Supreme Lord 155. That
1000?
Dibya. 2022 8 Supreme 155.
Yes. Paragraph number.
My Lord will come to page 4. Your Lordship will take page 3, my Lord, para 5. The first and the second respondent filed counter affidavit separately. They did not dispute the certification of the permanent disability by the medical board considered pursuant to the direction of the High Court. True that in the counter affidavit, the second level took up the stand that just compensation was awarded by the High Court in appeal, and the appellant herein therefore not affected. I will come in the middle of the top lot, line below, line 10. At the time of the accident, the claimant was a minor aged about 2 years, and its serious consequences and impact are reflected in the medical certificate issued pursuant to the examination conducted on 19/5/2018, which after 20 years of the accident. Lord, this was accepted, Lord. The evidence, parasitic, the evidence or record would undoubtedly show that the appellant had sustained various serious injury in a motor accident involving the two vehicles mentioned here. Even the same virtually doomed her to.
Okay. On to other points.
My Lord. My Lord, the one is 2009 judgment, Lord, 2008 Supreme.
Relevant paragraph.
Para 7. Respondent preferred an appeal there against the High Court by reason of the impugned judgment without there being any matter held. In the chief examination.
2009 decision, paragraph number 7.
Yes, my Lord.
Respondent preferred an appeal.
Yes. The High Court by reason of the impugned judgment without there being any. In the chief examination, the claimant admitted he is working as hired helper. Taking into consideration the above, the certificate issued by the doctor PW2 cannot be relied on. We came across a number of cases that the said doctor is issuing certificates fixing the permanent disability which is not proportional to the injury. Now, this is the finding. Para 10, you will could see. Did the case involve a contribution on the part of our answer thereto is rendered negative? The High Court with utmost should have bid Should not have disbelieved the evidence of a doctor of a government hospital on the supposition that he had been issuing certificate fixing permanently which was not proportional to the injury. Even no such suggestion had been given to him. That was never the case of the respondent. In his cross-examination, he categorically stated that he is a specialist surgeon and not orthopedician, and he had assessed the disability correctly. So, but he was also authorized. No, in the cross also, no question has been asked to him as regard his authority to depose. And in the chief, he has said before he was present when he was examined before the board, and he only said that he had not done his treatment earlier, but that cannot go against that certificate. Moreover, he was authorized by the board. I have one more judgment, 2020, Supreme SC 555.
Paragraph.
Para 7.
7.
Yes.
Yes.
Yes. See, 2 lines below, my lord. The tribunal disbelieved the claim of the appellant he was earning so and so.
Paragraph number 7.
Yes. The tribunal also refused to give any credence to the disability certificate filed as
No, there's a decision of
the ground
2025.
that,
Which decision? There's 25 decision.
that Navjot Singh.
Prakasanda Sharma.
Navjot Singh, my lord. Navjot Singh, lord, perhaps I have
That
not.
decision has not been
Lord,
taken.
sorry, I'm sorry.
Yes.
Para
In grievance.
my lord. In the middle, my lord, of the para 7, the tribunal also refused to give any credence to the disability certificate filed as Exhibit 35 on the ground that the doctor who was examined as a witness to prove that this was not a member of the committee which issued the disability certificate. The High Court reversed the finding of the tribunal with regard to this and held that the oral testimony issued of the medical officer cannot be totally discarded as he was able to identify the signature of the members of the committee which issued the certificate. In our case also, my lord, he has identified the signature. So, my lord, that the disability certificate could not be and cannot be discarded, my lord, in the case.
Okay.
And my lord, on the issue of fraud, my lord, perhaps it's no questions have been raised, my lord. And my lord, lordship would see, even if the tribunal had gone into, even now also we examine these exhibits, my lord. It's not a case as if 2006 documents have been placed before your lordship. My lord, because of the runtime error, my lord, 2006 has come. That document also has a date of 2008. All this, perhaps they have corrected later on, because there is a gap of 2 years exactly. One issued on 13/10/2008 is showing 13/10/2006. Similarly, there is one document which says 14/10, it is 2008, it is still showing 14/10/2006. And no issue has been raised in the cross examination. So therefore, my lord, the appeal filed by the insurance commission should be dismissed, my lord.
Then,
He has
madam, you have not pleaded this brought in your memo of appeal also? Did you?
No, no,
No.
that is not TA, but I have shown the documents, Lordship. But Lordship, the judgment relied upon Vidipya that after 20 years the he has taken. Lordship, the situation is totally different from our case.
Okay.
In our case, the person in cross-examination, he said that he came in a bus. But here, Lordship, paragraph 6 in the judgment, the court, apex court has mentioned how the child was. Lordship.
Okay.
So the evidence on record would undoubtedly show that the appellant has sustained very serious injury in a motor accident involving the two vehicles mentioned herein before, and the same virtually doomed her future. Besides the undisputed details regarding the disability certificate by the medical board, the appellant has produced photographs in this appeal revealing her pathetic plight. No doubt the trauma and the horror which she has experienced and experiencing are inexplicable and cannot be expiated appropriately, as the situation is indisputable that regaining self-reliance, much less recuperation, is totally now an impossibility. Obviously, the corporeal independence is lost forever. The state of her lower limbs, as revealed from the photograph supporting the certification of the opinion of medical board, would suggest that she could never be cursorily or even stretch her legs. In totally different logic. In our case, the so Lordship, and the disability of 70% and loss of income of 80%, that also Lordship will look in ye of Rajkumar Ajay Kumar again, Lordship.
Okay, we will take.
Because Rajkumar Ajay Kumar says that disability itself is not loss of earning, Lordship.
Tribunal has to assess the functional disability and the actual disability.
Yes, Lordship. That is, and this
That has not been undertaken by the tribunal.
and because the tribunal could not undertake because disability certificate is mentioning the injuries, not the disability. That is why I wanted it to be remanded so that they can, if they have, they can produce a proper disability which mentions the disability of the person. Here it is all injuries.
Now there is no scope of producing the disability certificate again.
No, Lordship, but here it is all injuries. Injuries that is mentioned.
We will see whether that can be treated as disability certificate or not. Yes, madam, any submission? No.
If I'm reading it from the judgment part, because we don't have any other thing apart from memo of appeal. So insurance company has deposed evidence on the point that claimant is not a third party with respect to the insurance policy law. With his
Pardon?
Claimant is not a third party in respect to the insurance policy of his vehicle.
Okay.
And second point is that driver of the offending vehicle is already, police has submitted the charge sheet against him. And
So
at the
you have disowned your liability.
Yes, Lordship. And at the time of accident, when it occurred, the vehicle was duly insured with the Orient Insurance Company. The insurance policy was also valid. That's it, Lordship. We don't have any contributory negligence, but solely accident took place by the offending vehicle, Lord.
Okay. Heard Ms. R.D. Mazumdar, learned counsel for the appellant. In appeal number, MSC appeal number 585 of 2019, Mr. Dubey, for respondent number 1. Respondent number 1 in MSC appeal number 585 2019 and Ms. S. Day. S. Day. Dev. Okay. The learned counsel for the respondent number 5. Argument concluded, order reserved. And in other, you take down. Heard Mr. Dubey, learned counsel for the appellant, and Ms. Mazumdar, learned counsel for the respondent number
3.
Respondent number 3, and Madam Dubey, the Dev for respondent number 5. In both the appeal, you are 5. Argument concluded, order reserved.